her call again, and then she just added another phone number to the 13-year-old grandson who's possibly with the daughter. Step out with this.
2412.
Veteran crisis hotline's calling in, so they have a female veteran's off her medication. She's over at the safe haven. Detective 12, take a check that one out.
6 bullet, 2-1, start taking shots.
Office still stands for talking. No. Offender in custody. Very simple with it. Okay. If anyone else close might just rest off, let me know. 10-5, sir. 33.
3-3. Supervisor found the application report with an arrest attached.
Step out with this.
You know I can't come on to the saxophone. Come on, saxophone. Come on, saxophone. Where you at, saxophone? Come on, saxophone. We need to hear you, saxophone. Talk to us. There it is. Yeah, we need to hear that saxophone first. Good evening, everybody. Thank you for hopping in. Appreciate you so much. We're going to be having a very interesting show tonight, I can imagine. We're going to be having some special guests tonight. We'll be having Silky, Golf Inspector General, and Yoli on here at certain points. And we're going to be going through the court hearing from yesterday. We're going to be breaking it down. We're going to be taking your calls. So if there's anything you want to say, take your notes. And I'm going to end the show. What I'm going to do is to end the show, I'm going to leave 45 minutes for phone calls if anybody wants to call in. So if you want to call in, you'll see the number pop up in chat. Just go ahead and write it down. And then when you call, we'll give you 10 minutes to let us know how you feel about whatever we discussed or about the case that we're talking about. So that'll be interesting. Can't wait. We need to set aside a time for that, you know. So I'm like working on different things. Speaking of, if you are part of the Discord group, you'll see the link drop. You don't have to be a member. You'll see the link drop through chat. You can just click on that, or if you want to request it, we can go ahead and drop the link for you. Opened up a bunch of info drop folders for you all. That way, you guys do so much hard work out there in the community, and I think it's a great way to have it all organized. So if you are part of it, check it out. If you're not and you are on Discord, go ahead and click that link and you can join and check out all that stuff. It not only for the community, but for everybody. And I want to highlight everybody too, because you guys do amazing work, and I think it's going to be a way that I can even showcase and highlight that even more for the future. Other updates coming soon, but as the days go on, as they say. So we'll go ahead and get into tonight's show. We'll say hello. So just keep in mind, we'll keep your phone calls for the end of the show. Appreciate you very much. And there is a new document. Of course, there's always a new document. We'll read that too. What's up, number 3, Kib Kitty, Diana, number 4. Uh-oh, who got 1 and 2? What's up, old hats? I heard that Judge nearly slipped by saying Coburger Island. See, Judge was chilling. I even left it in my highlight earlier. If you didn't check it out, here's a link. I even left it in my highlight earlier. It's like, you know how Judge was yesterday. He was all like, you know, doing the stretches during the hearing, trying, chill on the beach chair in Coburger Island. That's where he was at. He got confused for a minute. So did the prosecution, right? Who thought we'd ever see a BT brain fart live? That was amazing. You'll see that too if you didn't see the court hearing yesterday. A BT brain fart live. It was crazy. Happened right after 116. Remind me when we get to that, okay, old hats? Thank you for hopping in. Appreciate you. 49er girl, ticket number 7. Number 8 is great. What's up, Jeannie? How are you? Yeah, we'll be going through it. Trust me. We're gonna be breaking this down. Golden ticket number 10, Mary. Thank you so much, and thank you for being a contestant on the game show, Mary. Wasn't that fun, everybody that hung out at the game show? Oh, it was good stuff. Mistaken ticket number 12. Thank you. Caddy ticket number 11. Appreciate you. Echo golden ticket number 13. It is lucky, isn't it? It was lucky yesterday when Sea Dog was a contestant for Deal or No Deal for the game that he chose, and That case number 13 was good because I think it was like 500 and that was it. It was a good case. Lucky number. Hope you are too. I had to take some Claritin again. My sinuses, I have such a pounding headache right now. Collateral damage, ticket 17. Love bomb to you all. Appreciate you guys so much. John Morgan, ticket number 21. Thank you. Mary, ticket 18. Thank you. Appreciate you. What's up, Crystal? Look at those emojis. Such a colorful mixture. Katrina, ticket number 23. Thank you. What's up, Bine Maha? How are you? American Princess. What's up, Mama 5? Yes, EXMK. Prayers. Man, I want to hear what you guys think too. I thought about maybe opening the panel up later on too. And seeing what you guys think, not only calls, but maybe open panel later on too, just to see what you guys think about the court hearing yesterday when it comes to the justice for these souls right here. And if you didn't see my highlight about the Healing Guard update, just go to my video section of the last two that I put out. How they minimize those 4 souls by saying that the Healing Garden is not only for them, but it's also for future tragedies. What a way to minimize. And then he sits there and fake cries like, President Green. It's disgusting. What a way to minimize these souls that we have displayed. It's that we care about, that we want truth and justice for. Not to mention the court hearing, because I thought that was a joke. But we'll get into that. But also the Healing Garden and how it's for future tragedies. It's disgusting. Maybe you don't know about it. Check out my video section. You'll see it. It's the second to last video I put out. Ticket 26 to know. Thank you. Appreciate it. Echo. Thank you so much. And thank you to Grizz, too, for the awesome help. What's up, Echo? Saxophone. I love the saxophone. I wish I knew how to play. I don't. I do not. I just know how to play guitar. That's it. I don't even know how to play the kazoo. What's up, Teresa? Just a guitar. That's it. That's it. Bianca, ticket 27. Thank you. Speaking of, I need to come up with a new intro song. Intro. It was very chill, relaxed. Right. And you got stuck. It's like, bro, I have piles of notes all over my desk. I have 5 different piles. Here's the one pile we're going over tonight for the show, for the court hearing. I have piles all over my desk, and I'm more organized here because it's like, okay, it's in this pile. Like, Judge is sitting here going, I cover other cases, right? Yeah, we do too, Judge. We do too. And I'm not a freaking judge. What? Maybe I should have wore my fry tie t-shirt tonight. Maybe I should have wore that. Crafts and Crime, what's up? Ticket 34. Hearing was very interesting, was it not? We're going to talk about it. What's up, Fallon? What justice? Oh, it was horrible for devaluing the If you guys didn't see it, here. It's horrible. I always say, hey, make a playlist for the Evil CJ show. That way, when I drop all these links for you in chat, you just click on it real quick, save it to a playlist, come right back. What's up, Golf Inspector? Thank you for hopping in. SM ticket 35. Thank you. Please hit the like if you haven't yet. It is the free boy. Lucia, what's up? Thank you for hopping in. Hello to you. There it is right there, the Healing Garden. You won't believe it, for future tragedies. I call it a what the fuck update, because I'm going to have some of those, just like the one I put out today. What the fuck update? Come on. All right. JJ, those Idaho. Yeah, that's what it is. That's what it is, Mary, because when I sat there and I watched it, those were my exact thoughts. Those were my exact thoughts. I was like, yeah, alum, alum. Birds of the same feather flock together. That's what you always been told. All right, let me see here. So, and then they discussed this February 28th TUI letter too. February from the FBI to the state. To the state. It's the truth, mama. Is it not true? Is it not true? Does a steak smell like a steak or a hot dog, mama? You tell me. Does a steak smell like a steak or a hot dog? it's uh it's called life and reality. That's what it is. That's what it is. Right, mama? True that. Right. You can't listen. Yeah. Let's get some cheap ass hot dogs from the grocery store and let's go sell them as steaks at the corner of Dollar General, right? Let's set up a grub truck of our own. Steak dogs. Right? Steak dogs. Angus beef. Ballpark subtitle. No, not here. Not here. We don't do that here. No. All right. We're going to get into this document real quick. We know that there's going to be a document. We know that. So we'll check it out real quick. Give me 1 second. I appreciate you all. Appreciate you all. We're going to have a fun night tonight. We're going to have a fun night tonight. We'll be right back. All right, here it is. This is the request to public, or I'm sorry, response to public records request. Now, on a scale of, let me see here. How do I ask you guys this? Yeah, we'll be getting into that in our part 3. Shout out to Kim too. We'll be getting into that in our part 3 coming up in a week. We'll be doing our show in a week for our part 3. What's up, Bonnie? We'll be doing our part 3 coming up not this Saturday, but coming up next Saturday. We'll be doing our part 3. So if you haven't checked out the part 1 and part 2, definitely check it out. But we will be discussing that in our part 3 as well. All right, so this is response to public records request. You could see her. Yeah. Oh yeah, I've seen her before. She accidentally, before she was on camera anywhere, she accidentally came on camera on our show on accident, and out of respect for her wishes, I hurried up and got rid of it, edited it, and then clipped out the part where she came on camera because, I want everybody to be comfortable. So we clipped it out, but I still have the copy where she accidentally came on camera. So I already knew what she looked like. That's why when people were like, yeah, if you were there live, you remember, because it was live. That's why when people were saying like, that doesn't look like her, I'm like, well, I don't know. It looks like her to me. I don't know what pictures. You know what I'm saying? Because I heard there's a lot of fakes going around. I heard there's a lot of fakes going around. So I don't know what other pictures people saw, but the camera that I saw, yeah, that she looked just like her. Response to public records request. As public records request was submitted to the Latah County Clerk on February 26, 2024, and subsequently forwarded to this court for review and a response, the request to examine and or copy records pertaining to the total costs to date of the case against Brian Koberger, including both defense and prosecution, and any other costs this case has, quote, required, pursuant to Idaho Code Section 74 102. This response is specific to records of the Latah County Judicial Department and, more specifically, records for which this court is the custodian judge as defined in Idaho Court Administrative Rule 32 Case 3C. First, Idaho Code Section 74 102 does generally give the public the right to examine any public record of the state. However, Idaho Code Section 74 1041B exempts from disclosure records contained in court files of the judicial proceedings, the court disclosure of which is prohibited by or under rules adopted by the Idaho Supreme Court, but only to the extent that confidentiality is provided under such rules. Idaho Court Administrative Rule 32 governs, quote, records of the Judicial Department, examination and accompanying exemption from limitations on disclosure. Rule 32I2E allows a judicial record to be sealed to preserve the right to a fair trial. Sealed court records are not subject to examination, inspection, or copying by the public. Idaho Criminal Rule 12-2 addresses as defendant's ability to file motions requesting additional defense services. Rule 12-2D allows the judge presiding over a case to request that the administrative district judge appoint another judge to consider and conduct any hearing on the motion and to decide on the motion. On January 6, 2023, this court issued an order appointing resource judge for this case. Thus, a separate judge is tasked with decisions related to any defense motions requesting additional defense services. This court has no knowledge of the costs associated with the defense of this case, nor is this court the custodian judge for records pertaining to the total cost to date of the case against Brian Koberger. This is to ensure that any decision made by the court are not in any way influenced by the cost of the case. Interesting. On January 13th, 2022, the resource judge tasked with evaluating and ruling on any defense requests for services issued and ordering sealed documents pursuant to Idaho Court Administrative Rule 32I2E to preserve the right to a fair trial. Therefore, all documents and materials related to cost associated with the defense's request for services are sealed and exempt from disclosure at this time. Additionally, the Judicial Department does not maintain any records related to the cost of the state's case. In addition to this response, explaining why the Latah County Judicial Department cannot provide the total cost to date of the case against Brian Koberger, attached is the above-mentioned order appointing resource judge and order sealing documents, ICAR Rule 32I. Additionally, the order approving appointed counsel's hourly rate, which is not a sealed document, and is contained in this court's case file, is attached. Dated yesterday. And that was the one that we read before. What's up, Yelly?
Hi.
How are you? Did you read
How
these?
are you? Oh, is there a delay? Is there a delay? Is there a delay?
Um, uh, Here, let me see. How do we figure out if? Uh, okay, I'm gonna move the screen. I'm moving the screen, and now I stopped.
Okay.
Is there a delay?
No?
No. Okay, cool.
Okay.
Did you read these at all?
Oh yeah, those are these requests for a public records request for the costs incurred in a Koberger case. Is that what that is?
Response to public
Yeah.
requests. That's what it sounds like. Yeah.
Yeah. So there's somebody in the media that's requesting
How much everything is.
yeah. And I bet I know why, because there's so much law in motion going on. Like, how much is this costing everybody? You know?
I mean, unless you're the state paying for it. I mean, does it matter? It doesn't matter. I'm sure it's going to be a lot. I'm sure it's going to be a lot. It's like when you buy a stadium right now for a sports team right now, it can be $1 billion, and then in 2 years it can be 10 billion. I mean, I'm sure it's going to be a crazy amount.
Right. So I think it's some news news agency that wants it.
Yeah. News Nation. What's up, Golf Inspector General? How are you doing this evening?
Oh, hello. Hi. Hi, Ellie.
Oh,
Hello.
hi, Golf Inspector. I've heard of you, but I've never been on panel with you.
Yes, it's a pleasure. Thank you so much
Yeah.
for having me, CJ. And
Oh,
it's
thank
nice
you.
to meet you.
Yeah,
Thank
nice
you.
to meet you too.
Let me do
I'm
this
wearing
contribution.
my granny glasses.
Hey, I got to wear mine too. Contribution call out. I got to wear them every day now. It sucks. Contribution call out, Bonnie. Thank you for the gifted membership. And Fallon was gifted the membership. Thank you very much for the contribution. to
Hello,
the
everybody.
community. What's up, Aeneas?
I'm gonna try not to look at the chat so I don't get distracted.
You're good. So, like, what do you think of the document? I mean, I don't know. Is it really I'm sure it's like News Nation or something like that.
Well, it
But
says at the end. It says who's requesting it at
is
the
it?
end.
Does it?
Mhm.
I never got. Let me see. What page? Do you
Mhm.
know?
And
Let me
it's like
see.
WKR.
Oh,
I don't know.
KHQ
Oh, up,
TV.
right there.
KH.
John Webb at KHQ TV.
You live in
KHQ.
You live in Spokane, Washington, John Webb. Who
Mhm.
gives a shit? It's not you paying for it, is he? They don't pay for this. It's Idaho.
Right. They just
It's
curious.
Idaho. It's Idaho. It's his business. It's a taxpayer's. If
Yeah.
you're a taxpayer, yeah, you should be able to have those documents today, or updated documents for sure, because you're paying for it. It's your tax dollars. But this
Yeah.
guy, he's not paying any tax dollars.
Was that the response? I didn't really get into the response. I know that it's a public records request for
Oh,
the
they're not
costs.
gonna. They're not. They're saying, as far I don't know, just from the first few pages to them, it sounds to me like they're saying, we don't know how much it costs or how much or this or that, so don't ask us.
To me, it sounded almost like a response to our YouTubers as well,
Hmm.
Yeah.
because we questioned the cost of all this. And I was under the impression that that is something that the judge would keep track of. But of course, I was wrong. He corrected me in this one.
He has other cases, Golf.
No.
He has other cases.
Thank you,
No.
Judge, if you're
The
watching this.
No, the judge
correct-
doesn't keep track of shit.
Okay, all
I'm
right.
sorry. The judge doesn't keep track
Well,
of shit.
I mean, part of his job is to keep track of timing, which ultimately leads to, hours of work that goes
Well,
into this.
I mean, I didn't know what caste was until this case.
Yeah.
And he obviously wasn't sure what caste was.
Yes.
It's not, he's
Evidence.
human.
Yes.
Okay, just because he's the judge doesn't mean he knows it all. He's relying on the attorneys to educate him.
Yeah.
So it's not surprising to me that he was like, caste, like, what the hell?
You know what's
No.
surprising to me is I have better handling on my notes than the judge does for all his different cases. Because
Mhm.
I mean, geez,
Yeah, he has other cases. He
I'm
has.
sure he does. But dude, I mean, does he not have time to prepare for the hearing before?
Oh,
I'm
let
sure.
me tell you, if I were in his position,
Come on,
I would make time to prepare
you
and
know,
know what the heck I'm talking about
you
and
know.
know like what the deadlines are and what the tolling
Um,
provisions are for
Yuli.
the alibi.
Oh,
I
Yeah,
wouldn't be nilly
you.
willy.
Yeah, you would know. You would know.
Go ahead.
You
I
would
have a
know.
question for you, Yuli. Does the judge have more than one death penalty case at a time, though?
Good
Yes.
question.
Yes. At least
Really?
in well, at least in big cities they do.
Okay.
There's all kinds of death. There's a judge in Orange, my area, 17th floor, I think. He only takes. He's the judge assigned to death penalty cases, and he has a whole full calendar, like I don't know, 200
Mhm.
cases.
Wow. Because I thought that surely they wouldn't give him like more than one at a time to
No,
focus on, right? Okay.
no,
All right. See, I
because
was
it's
wrong there
he's
too.
yeah, he's not the one that's going to focus. He's going to make rulings on what is presented at court. Okay,
Yeah.
so and he also some of the discovery when there's a challenge, right? So if there's a
Mhm.
challenge to discovery and we say, and the prosecution says, we don't want to give it, and the defense says, we do,
Mm-hmm.
we want it, we're entitled to it, the judge makes a decision.
Mm-hmm.
But the judge is not involved in get everything. He's like the person that makes rulings on objections,
Mm-hmm.
like what is admissible, what is not admissible, and so he has to be fair to both sides, right?
Correct.
So
Yeah.
so he's not someone who's going to have an intricate knowledge of the case. He may have a lot of knowledge, but he's relying on the attorneys to educate him. And mhm.
So in that vein, does he look at the case overall? Meaning, does he sees the
Mhm.
evidence that comes in that's been going back and forth between the two parties, right? So he has access to that.
Well, that's not evidence yet. That's not evidence yet. So what they're talking about is discovery.
I'm sorry, I mean discovery. Yes,
Yeah, yeah,
I'm
yeah.
corrected.
So,
Yes.
so just because something is discoverable means you can exchange it, you have access to it.
Mm-hmm.
That doesn't necessarily mean that it's going to be admitted into trial.
Mm-hmm. But he has access to it.
Okay.
So
When you heard Ann Taylor talking motions,
yes.
well, he will have access to it. He may not have access to it now.
He just
Ah.
won't have access to what the prosecution doesn't have access from when they worked with the other agencies. You know,
So yeah, this is a complicated case. So when a
I think
judge
there's a
is
lot of FBI in this court hearing too. I feel like,
yeah,
yeah,
so the judge isn't doing the lawyer's work. Okay, the judge
Mm-hmm.
has to be educated by the lawyers, and
Mm-hmm.
that they have to be educated. The judge has a case. He has the complaint. He has the charges. He has motions that are filed and evidence that are attached to the motions
Mm-hmm.
that he rules on, and he has information on what the parties bring to the court if there's a discovery dispute, right?
Mm-hmm.
So he has that information, but he's not privy to all this other stuff. Normally the discovery, it's just exchange of information between the parties. If there's a problem, then you go to the judge. So he has some knowledge,
Mm-hmm.
of what's going on. But yeah, he's like, educate me,
Okay.
like really, like
yeah,
educate me.
Yeah.
yeah, he is. Yeah, he is.
No, because I was always curious, like how much does he? I mean, he's seen the letter with the timeline, obviously, because he was talking about that. So I'm always curious, like how much of that
Mhm.
does he actually know? So, like, how much does he put
Well,
himself
you know
in?
what? He only sees what is put in front of him before trial. because it's disputed,
Uh-huh.
and then he sees the evidence as it comes into trial.
Ah.
Okay.
Okay.
Mhm.
Okay.
These judges are not intricately involved in that's what the lawyers are for.
Yeah.
Okay.
Uh-huh.
If the lawyers have a problem with discovery, they bring it to the judge's attention. And to that, it's
Okay.
when the judge gets wind of what's going on. He has some access to the evidence. But,
Mhm.
you know, normally attorneys are independent people. They work together, they exchange information.
Mhm.
And when there's a dispute, you take it to the judge. And so
Mhm.
that's how the judge knows what is in dispute. And he has to make a decision as to whether the party's entitled to the information or not.
Mhm.
That's why in one of those court hearings, remember when they had the experts there discussing the IGG and Vargas was on there talking. That's when he was even asking the witnesses questions because he didn't understand,
Yeah. He's not,
anything about it.
yeah.
Yeah.
He's being educated. And so
On
the
the
judge,
fly,
yeah, on the fly.
Mhm.
And you know, the judge is not going to be privy to everything. It doesn't surprise me he didn't know what CAS was. Maybe he's never had a criminal case where they have phone pinging or whatever. I didn't know what CAS was until his case.
I didn't either.
So yeah, so he's a normal. He's just like you and me and CJ. He's a normal person.
Mhm.
Okay, so he may have a law degree, but that doesn't make him all knowledgeable about all of the facts of the case. He
Mhm.
can't.
As
He
the
can't
jury,
be.
as the jury too. That's why I always say, like, can you imagine, like, what they're gonna have to think, the jury pool that they're trying to go after, because us here on YouTube have gone through witnesses from even other cases when they've talked about data and evidence, and we've been like privy to all these different experiences from all these different cases with all these different angles when it comes to this different evidence. And so, like, these jurors too, they're going to be learning on the fly as well.
Mhm.
Well, you know, there's instructions that the court gives to the jurors, and you know, you have to follow. The jurors have to follow those instructions, and that's one of the things that you ask a juror: can you follow this instruction, even though it seems counterintuitive, even though it seems like this isn't right, but that's the law? Can you do that?
Mhm.
And if a juror says no, okay, well then you challenge them for cause because they can't follow the law.
Mhm. Well, what's surprising
Simple.
to me in all this is that
Called it, Steve.
the judge, they were talking about exculpatory evidence, right?
Right.
So how was, in that case, the way I understand you, how would the judge know if there is exculpatory or not? Because the judge is acting like there is no exculpatory evidence.
Well, you know, the exculpatory has to be exchanged between the parties. So
Mhm.
a judge doesn't need to get involved.
Mhm.
Okay. The prosecution needs to turn over exculpatory evidence.
Mhm.
If the defense believes there's exculpatory evidence that is not being turned over, then that's when you go to the judge.
Mhm.
Okay. And you say, we believe that there is, exculpatory evidence that is not being produced. And this is the reason why we believe that. And we want it. Okay. Then the
Mhm.
defense gets to give their say, and the judge decides, okay, they're entitled to it.
Mhm.
So that was the whole thing with the IGG. So, they miss a crucial point, because it's really the fruit of the poisonous tree. And I don't know why people haven't been mentioning that, like the attorneys or whatever. But the issue is the way that they got the IGG, they got it partially from Othram, and then the FBI continued it.
Mhm.
Okay, that can be challenged because there's laws and procedures from the Department of Justice that the FBI has to follow. Like, they're mandatory. So they're kind of like mandatory duties. So they have to have certain things. And so that's why Ann Taylor, one of her motions, she put together all of the guidelines and the procedures when you're dealing with DNA. She attached it to a motion, and she said these things have to exist because this is what they're supposed to do. They're supposed to have this, they're supposed to have that. So by Mr. Thompson saying, well, we've given them everything we have, we've given them everything we have. Okay, that doesn't answer the question. You need to find out whether these things exist somewhere else. Okay, it doesn't just say, oh, we gave them everything. No, you got to find out. It doesn't matter if the Idaho State Police was involved, if the FBI was involved, if the DEA was involved. The prosecutor has a duty as the person who is in charge of the case to get all that information. And I get it. It may be hard for him to get all the information. I get it. But if they don't have it, then guess what? They didn't follow procedure because they don't have it. And so there's a difference between we gave them everything we have and these documents do not exist. And in order to say that these documents do not exist, they would have had to have questioned the FBI. They would have had to question DEA. They would have had to question the Idaho State Police. Give me these documents, and if you don't have them, you need to tell me that they don't exist. Okay? So
they don't.
What are they going to do? They're going to say they don't exist?
They don't.
Well, are they going to make them up?
I've been saying it for months. They don't exist.
Yeah. Well, here's the thing. They did turn over some material to the FBI. I mean, some material was turned over to Ann Taylor to analyze. We don't know what it is, but you know, did they come up with that on the fly? Because
headers in redacted.
There were pressure, an actual order from the judge saying, produce it?
No, they were saying it.
I have my suspicions.
At the beginning when he said we gave you everything.
Yeah.
They've been
okay,
saying it
everything that they have. Okay.
Right.
That's not the standard. The standard is it's
what they're allowed to have because of the other agencies involved.
Yeah. But they have an obligation.
They obligated to give them everything they had. That's why they keep saying it.
And there's
a
problem.
They keep saying it.
No, honey.
They've already gave it everything.
Honey.
They already gave them everything. They've been saying it for months.
I'm sorry for all the questions, but since you're here and I know you are a lawyer, I appreciate you actually answering those because these are critical questions. We need to know when we go into this. I had no idea. You know, I don't know much about court. I don't follow much cases. I'm not really into true crime at all. So for me, this is all new, and I would like to make informed decisions on everything, obviously. And so thank you for.
So
this is a good question right here. Why do you? How do you? If you're not using IgG, right? How are you using it to arrest Koberger?
Well, this is why I get frustrated. Okay,
like how?
I caught up on the hearings today, and you know, this is why I always say, and I'm not criticizing Ann Taylor. I don't know what the procedures are over there, and I don't know what relationships she has or how it's supposed to work. But if I were there, I would definitely want a hearing where I go through the probable cause affidavit and show the judge that yes, they did use it.
Right.
For probable cause.
Right.
They did. And so when the judge is sitting there saying, I asked Mr. Thompson if he's going to use that in the trial, and he said no, that's not the question. The question is, did you use it to identify my client?
Exactly.
It was.
I think what she's
how is
doing.
Did you use it for the probable cause?
But I think she's saving that for later. So once we're in trial, I honestly, I don't think the judge is going to let the IgG
no,
in. She shouldn't wait, is what you're saying. I just assumed she was because I mean, you know, judge is not going to let the IgG in anyway, but she's going to press on the issue. Like, how did you get to my client? And what it seems to me, like from what we heard yesterday. Sorry. Go ahead.
No,
Well,
finish.
so for me, what it seemed like from yesterday's hearing is when he's talking about the
Go
IgG,
ahead.
he's like, well, I've seen the timeline. And, and there's so much in that timeline, that letter that they gave them, that is going to substantiate
The
the end
letter from the
result.
FBI.
Correct. So I don't know if it's from FBI, but there is a timeline letter they were discussing yesterday. So I don't know how he can make that judgment, because ultimately they're telling us in the PCA that the arrest was made on these and these grounds. The route he took, the IG, or his
Yeah.
DNA on the sheet, but they can't use it because there is
Well,
no.
They
Yeah.
don't. Yeah, they can't get the work from the FBI.
So it
Let's
frustrates
be
me as
honest.
well.
It's like the FBI used a method that they don't want the
okay.
general
When
public to know
when the judge
about.
made that order, okay,
Hmm.
No, go ahead.
go ahead, finish it.
No,
CJ.
go ahead. No, go ahead. I
Oh,
was just making a comment.
finish.
I don't
Come on.
even. No, it's okay. I don't
You
even
don't remember what you were
remember where I
gonna
was going with it. Yeah, I do my
No.
shit on the fly.
Okay. No,
Do my
what I
shit
was
on the
gonna
fly.
say is that there's a when you're in, I think this is like the United States Constitution. So like when you're a defendant and you have accusers, no matter who the accusers are, whether they're people who have scientifically pinned you to a certain thing, whatever, eyewitness, whatever, you have the defendant has a right to confront their accusers, right? So when you have a multi-state investigation or multi-agency investigation, presumably the DEA, FBI, Idaho State Police, they were all involved. Okay. So the prosecutor, as a person who is bringing charges, he cannot say, well, they won't give it to me, so I can't give it to you. No.
Yeah.
What he has to do, he has to inquire, do a reasonable good faith inquiry, and ask for these documents.
They did 2 times.
And if those people do not have, those agencies do not have those documents, what?
They did twice. They did twice.
They did what?
Bill Thompson said in court 2 times that he was going to reach out to those agencies to see if there was anything else. They did twice.
Right. So they got the IgG because they got the IgG information, because that is what Ann Taylor is talking about when she says that she wants her investigators to be privy to the IgG information. So they did get the IgG stuff for their experts to look at. What they didn't get is the CAS report. So what was I saying?
No, they're still waiting on IgG also.
No, I think they gave it to her.
No, she says it in this last court hearing that IgG is part of it. Yeah, IgG is part of it. And this is what I'm saying. Like the FBI
well, why
does
is she
things...
asking? Why is she asking for her experts to be her experts are going to look at the information, and then she wanted her investigators to be able to look at the IgG information.
Yeah, I'm trying to answer. Because the FBI practices investigative techniques that they don't want the public to know about.
Mm-hmm.
So what I've been saying this whole time is the FBI used, because they referenced it before, the FBI used investigative techniques to get Koberger's tip. They can't share that information with the prosecution because it's classified. Therefore, the prosecution doesn't have all the information. That's why the information's missing in the discovery, but that's why Bill Thompson and the prosecution keeps saying that they don't have anything to offer, because they truly don't, because the higher agency won't share that technique.
Mm-hmm.
And that's why they only have the tip, not the homework. Because the FBI is the one that did the homework, because ISP couldn't come up with it. Orthram couldn't come up with it. But who are we? It's classified. What are you? No judge can argue classified information. Well, you can't say FBI. Give me the techniques that you use
Not the techniques.
that are classified.
It's not
How
the
you got
technique.
to Coburg?
The data.
They gave you the tip. They're not
The,
giving you the homework because it's classified.
well, the homework, if they give the data,
The tip, the name.
not how they got to the data, but if they give the data to the defense, see, I don't know if that's, I don't know.
They can give
I'm
you
not sure.
They can give you Idaho. They can give you ISP lab work. They can give you Orthram lab work. They can't give you the FBI lab work. The FBI lab work's the one that got Koberger's profile, not ISP, not Orthram. That's why the
Okay.
FBI took over. So that's why I'm saying you can get the IgG
Mhm.
from ISP and Orthram, but you're not going to get the information from the FBI because it's classified. That's why Bill Thompson says he only has 95%. That's why he keeps saying he's given them everything, because they truly have given them everything. They're not lying to the court.
Okay.
The FBI has it. They used
Okay.
a technique that I think is classified, and they don't want the general public to know how they got the tip, but they just said, here you go. Here's Koberger's name.
And then
That's why they're not using the IgG.
they burned the evidence.
Yeah, which is normal because I looked it
Yeah.
up. I was like, is this normal for the FBI to get rid of, homework
Well,
when
according
they're
to
doing it?
Vargas,
And it
according to
is.
Vargas,
Yeah,
yeah,
it is.
it
It's
is.
totally normal. So I'm like, okay, nobody did anything wrong.
Okay.
That's why everybody's gonna, that's why she needs more, because she's like, what am I supposed to do with this piece of paper that says, hello, my name is Brian Koberger on
Well,
it? I'm just saying.
Yeah,
I'm
true.
just going by memory, which is not very reliable. Yeah, I'm going by memory where the judge ordered he ordered Bill Thompson to get the information from the other agencies.
Mhm.
Now, if the FBI has a special procedure that they use, okay, that special procedure is maybe private. It's like a trade secret, maybe like in civil cases, a trade secret they don't want to disclose. But the actual data, the DNA, the specimen,
Whatever the FBI did, it's classified.
those should be provided to the defense so that they can test it.
Yeah.
Yeah, but
Yeah,
what are
whatever
they
the
going to
FBI
do
did is
with it?
classified, but the specimens.
Yeah, ISP and Orthram. I'm sure they got it. We're not talking the specimens. We're talking
Yeah,
the homework. We're not talking
exactly.
specimen.
The trace. So
Right.
Yeah.
basically, you're
Okay.
we're.
You
I
can
think
test it.
what CJ is saying, like we need the evidence of trace evidence. Like
Right.
where is all that? We don't. The data is one thing. That's okay.
Mhm.
But where's, like, how did you handle it? How did you do it? Like,
Right.
how did you get to Brian? Back to
Right.
that same question.
Nobody else could.
The chain of
Well,
custody, and that's what it's lacking, I think, is
yes.
that, and that's important
Well,
because you're dealing with DNA here. You're
Right.
dealing with IgG and DNA.
yeah. And there are rules in the Department of Justice that says to the FBI, when you're involved in an investigation like this, you need to do this.
Yeah.
And I don't know. I keep harping on these rules, and
I think everything's being done. I mean,
I
it's
their
as
rules are
simple
very
as the
specific.
FBI. Yeah, I think
Well,
everything's being done. I think it's
it's
the
it's
FBI has classified
perhaps.
information that the prosecution already used. I've said it for months. The prosecution already used an example of the FBI not being able to supply how they, their homework for a case, and they used it to make the argument that we don't have everything. That spawned me to then discuss another case, a
Mhm.
real case that took place where the FBI again didn't want to show the techniques, and so the prosecution didn't have that in the case, and that person was set free.
Yeah.
I mean, it happens.
Mm-hmm.
The FBI is classified, CIA is classified, our government's classified. If they step in to help, unfortunately it could be classified. ISP couldn't get a match. Orthram couldn't get a match. That's why the FBI took over.
Mhm.
Whatever they did from that point on, because there wasn't a match before the FBI took over, and there was when they took over. So whatever that data and homework and tests and all this other stuff, which got them to look at all the papers that says, okay, this is Koberger. All that is classified.
Well, maybe that's why there's a gag order. I don't know.
It could be as
All I
simple
know
as what
is that the
Vargas
U.S.
said.
Constitution.
Yeah.
Yeah, and I'm just talking generally here because I don't practice criminal law, but generally, the U.S. Constitution allows you to question witnesses against you. It doesn't make a distinction as to whether they're FBI or there's all kinds of multi-agencies that have to abide by the DOJ's discovery rules. And so yeah, the procedure or the method by which they did their analysis, that's like work product. That's attorney work product. In other words, maybe classified in those terms.
It's happened before.
Yeah. So what I would argue is that, whatever the FBI has needs to be produced. And if they are claiming a privilege, like it's classified, then they need to put it in a privilege log. Well, I don't know if they did or not. I'm just saying.
Maybe they did. I mean, we're already this far along in the
did.
court hearings, and Bill Thompson already said 2 times that he was going to reach out to the other agencies to ask for,
and
time is of the essence. Is what
and
he
actually,
said.
I believe that Ann Taylor did ask for a privilege log.
And like, it's not the FBI's fault, Memory. I don't think it's like that. I think the FBI did it. Look, if you're using an advanced technique that's classified and you don't want us to know how you can solve crimes, please do. Right?
It's work product. Yeah.
Please do. So it's what it is it lands on the fucking MPD not having more than what they should. Cause,
exactly.
Right.
No, I see what you're saying. It's work product. It's attorney, like in civil cases, it would be attorney work product as to how we came to a certain finding. If we used experts that are consultants, it's work product until the time comes that you disclose your experts. So yeah, no, it's like a trade secret. In business cases, they say, we're not going to disclose this because it's a trade secret. It's how they do things because they don't want the public to know. I mean, the FBI doesn't want the public to know how they do their things because then criminals are going to know. So yeah, I get it.
But I get your frustration too, Yoli, because here's the thing is like they discuss the fact that, okay, IgG is one thing. Let's scrap that, right? We took his DNA directly is their defense, right? But how you can't backtrack on that. You found him through a method. And that's the fruit of poisonous tree. Exactly. So it's very frustrating that she's not arguing that point. Like you say, as I say, I thought she was holding that back, but you said that you wish that she did it now and it would be more important to bring it up right now.
Well,
correct.
And again, I'm not gonna say, I'm not gonna say that or undermine her in any way. I've been in high profile cases, but not criminal ones. But what I can say is that to me, even if I'm not a criminal defense attorney, I would be arguing with a judge and I would be arguing until the cows came.
Maybe she is
home. That, okay, let's go
Maybe
over the probable cause. Well, it would be in a hearing, wouldn't it?
I'm sure she's doing I'm sure she's doing everything. I mean, we don't know the water coolers talk,
Well, I don't know, but when the judge said, I asked Mr. Thompson if he used any of that IgG information to get to Mr. Koberger. He said no.
Just this.
Okay.
This.
Let's just take his word for it.
I do. That's why I say the FBI is classified.
Then how come it's all over the probable cause affidavit.
Mhm.
Let's remove it then.
Mhm.
I would say let's remove, okay, Mr. Thompson, let's remove all of the IgG information that you put in the probable cause affidavit in Idaho and in
They couldn't
Pennsylvania,
get an
and
arrest.
let's see what
That's
we
the
got.
thing. They couldn't get an arrest until they had it. That's why I say if there's no DNA, there's no PCA. If they didn't have the IG, for real,
Yeah.
if they didn't have the
So
IgG, they wouldn't have had the freaking arrest. How do you arrest somebody the way that you arrested them without even bringing them in for questioning, without even asking them for a sample? You got to get daddy's DNA from the trash
no,
can.
it's bullshit.
What's up, Silky? Thank you for hopping in.
Hey,
It's
hey, Yoli.
Hi, Silky.
bullshit.
Hey.
So that is just my take on it. Hi, sweetie. I'm glad you're here. Silky always brings good vibes.
Hey, just FYI, Yoli, I haven't had time to do it yet, but I got some info on another body parts case.
Yeah.
Really interesting. So,
Whoa.
when your schedule, like, you know.
Oh, my schedule opened up a little bit.
Yeah.
So
okay.
I have a case too going on right now that I would like to talk to you about, involving this is a sad case. It involves the burial of a stillborn baby.
Oh.
And they
Trigger warning. Trigger warning. I didn't know this was trigger warning, please. Oh boy.
They confused it the wrong. It was a male and they confused it for a female.
Wow.
But anyway, it's on appeal because Forest Lawn has big attorneys. But in any event, that we'll talk about that later.
Yeah, sorry, I didn't mean to take over your show.
So yeah,
I don't.
I think we're all on the same page. We know
you are spicy. We know that you are spicy.
Body part people.
I didn't know we were gonna go the baby route. That's where I was like, all right, trigger warning.
You never know what's gonna happen.
No. So anyway, so I think we're all on the same page. I think we're saying the same thing, just words. But yeah, I mean.
Yeah, that's what I feel. That's why I say, like, that's why they always said from the beginning they're not using the IgG because they were never given the IgG because the FBI wasn't going to share their work because of whatever investigative techniques they're using. They just handed a piece of paper that said Brian Koberger. It is. Look at the rest of the PCA. It's bullshit, is it not? Is it not?
They're saying that my audio cuts in and out.
Yeah, you do skip a little bit, but I think it's the feed on her end.
Should I use my phone?
I mean, it doesn't happen very often. It skips here and there just from your connection. Okay. It don't happen. I don't know. It don't happen very often. I don't think. Just a teeny bit. No.
Yeah.
So Yoli, so from your perspective,
if it becomes annoying, let me know and I'll move.
No, that's good. I think it's fine.
Yeah, go ahead, go.
So from your perspective, what do you think about why would she hold back on that right now? Is there a reason? Valid.
Well, I mean, she tried to do it with the grand jury, tried to get the grand jury dismissed and it didn't work. So I guess she did address it in that respect. But so maybe she probably has addressed it, and maybe, it's just that we're not privy to everything. So that's what makes it difficult to know. Because like CJ said, maybe she's done that. Maybe she has. Okay. And I don't know. I mean, maybe she has, and maybe it was in a closed hearing.
I would think, I'm just saying, I don't know, just from even how she was yesterday in court, and we're going to go through that here again shortly, everybody. I just feel like just every time you watch her in court, I feel like she's giving Koberger everything she's got, especially the last two hearings, because the hearing before, when she got a little emotional and she's like, the team is doing everything they can. Yeah. I just feel like she really is, doing everything she can.
Yeah, I do too. I've always said I can't judge her. I can't judge her, number one, because I'm not a criminal attorney, but number two, I'm not licensed in Idaho, and things move slow in those places. I get it. I mean, I was in St. Croix working on a case And damn, they were slow. The humidity or something got to them, and they were just very, very slow. But oh my god, it's like,
well, I was going to ask
man.
you if you had a good time, but never mind. I already
Oh,
know.
I did, but it was like
Oh, okay.
so slow. It was like, man. So they'd be picking their nail. So no. Anyway, so it's slow going. But the one thing I do, I think Ann Taylor is doing what she needs to do all the way around.
Yeah.
She may not be as feisty as I probably would be. But maybe I wouldn't be given all the scrutiny, you know? It's like, whoa.
Yeah,
you know?
might backfire.
It might, yeah. I mean, you know,
it might actually up there because they're pretty reserved
Yeah.
up there, you know. So
Yeah.
it might actually. You're right. It might actually work against her if she does.
But one thing that I find, these are the things that kind of make me feel like that. It's just something that I noticed. Okay. So she filed a motion for prosecutorial misconduct. Remember that?
Yes.
So she basically accused the prosecution of prosecutorial misconduct. Okay. So when you do that, like, for example, if I file a motion for frivolous discovery delays and they get sanctioned or whatever, I don't go around saying, oh, later. I don't think it's him. I think he's doing a great job. I don't, like what she was saying in court. Because she did file a prosecutorial misconduct motion against him. So for her now to be saying that, it's kind of curious to me. Maybe the prosecutorial misconduct motion was a nothing burger, and maybe she was told by the judge there is no prosecutorial misconduct, and she got her ass handed to her. And now she's basically saying it's not him, So it's kind of weird to me because we don't get to see those hearings, where the grand jury bias hearing and then the whole prosecutorial misconduct, because you allege something against somebody, and then you say things about them that are contrary to prosecutorial misconduct, and it kind of confuses me. So that's all I have to say about that.
I don't know. It was weird how she kind of backed off, a little bit with that.
Yeah.
Because to me it was like, wow.
I would be on fire.
If you are going to go that route, you think you would have, something,
oh my
something
God.
in the hat.
The other thing about the Supreme Court, they don't even know what's going on. They filed a permission. They filed something to get permission to go to the Supreme Court. Supreme Court has to approve
that's a good point.
it. And so the judge is asking, does anybody know what's going on with that? It's like, okay, did it get lost in the shuffle? They filed it and nobody knows. It's like, and then the judge is asking, well, do we stop now or do we wait until? It's like, fuck me. I'm sorry. It's like, did you guys not look this up before you came to court? Like,
didn't she back off?
Well, maybe they're I don't know.
I think she was pressured, Steve. I mean, you saw how the judge was like, look, you can go to hire people if you want to, but they're gonna ask the judge his opinions, and well, I would hope they do, but you don't want to go that route. He was kind of like, it's like I was saying, if you're an 80s kid, it's like your parent looking in the back seat saying, don't make me get back there, like don't make me come back, right? If you're an 80s kid, you know what I'm talking about.
Sure, but if there is that's a substantiated.
Yeah, they just haven't received a response from the Supreme Court.
Yeah. But if there is a substantiated concern about what went down during the grand jury proceedings, which she obviously read, then why would she back off on that? That's some bull, because even if the judge says, I don't think so, I would take it all the way. I would absolutely take it all the way.
Yeah.
Because you don't start that fight unless there is something there.
Right. You don't have a cat in the hat.
Yeah.
Right. Why are you going
Well,
to
that
say
is
you
what
have
she would
one?
be appealing. Is the prosecutorial misconduct
Mm-hmm.
and the bias, the jury bias, whatever.
Mm-hmm.
Those are the things that she would be appealing to get the indictment dismissed. So while she did a permissive appeal, like she asked for permission, she's
Mhm.
waiting to get permission. So she's waiting to get permission on a motion that accuses him of prosecutorial misconduct.
Yeah.
And on the other hand, she's saying, oh, I don't think he did anything wrong. I don't think, and it's almost like, why even say that? Just say we're waiting on this discovery and we haven't received it.
Yeah, but because Thompson seems to be he jumps up every time she,
Yeah, he
you
does.
know, he's like very,
He has
woof.
his paper. He starts going like this, like shaking his papers and shit. Yeah, you're right. He just jumps the
He
fuck up.
jumps up. He can't take it. Like he has to. Like it's almost like you have to stroke him. You have to stroke him like a child.
Give
You
him a
know?
spinner. Give him a
I
spinner.
know a lot
Yeah.
of things like that.
So maybe that's why she's like, I'm
Oh
not
my God.
accusing you
No,
of
but
anything
those
here.
are the things I
Give him a spinner.
yeah, those are the things that make me think. Those are the things that make me think, because if believe me, I've had my days in court and I filed nasty motions against counsel, and while it's pending, I would never say, oh, I don't think, oh, it's not their fault. No, it is not their fault. It's totally, I'm not blaming him. Well, you are. You're blaming
Mhm.
a prosecutorial misconduct, and you're going to take it up to the Supreme Court. So, to me, there may be a reason, and there may be a strategy that I don't know about, which she may have a strategy. But that's all I'm questioning, is just that fact.
Mhm.
I don't know whether it's good or bad. I'm just questioning it.
Yeah, but I see what you're saying, and it's absolutely true. But I see that other perspective too. That that man is like, he's got some sensitivity issues going on. Like there's something there that's you have to treat him with kid
She
gloves
said there's
almost.
something there.
Yeah, because he gets like so.
Wait.
Sus-
Who has sensitivity?
Suscake.
Thompson.
Yeah.
Oh,
Yeah.
Yeah, the whole time, every hearing, like even the ones from the beginning where he was like sitting and like where they had the two tables and there was only two people sitting there, and then he was sitting on the row right behind, and even then he like when something happened, he jumped up and started running up there. Judge,
Mhm.
judge. It's like, dude,
yeah.
Yeah, like he's got something going on. Like
but he's got so much experience.
yeah, like he can't say that. That's wrong. He's like that kind of a person. So
Yeah, he
you
knows everything.
Yeah, so I think from that perspective, she's like, listen, I'm not accusing you of anything, but yes, at the same time, I am.
I just wouldn't bring it up. I just wouldn't
Yeah.
bring it up. I would just say we don't have this discovery yet.
Yes.
Period.
Yes.
Yeah,
Like-
Maybe he's trying to play himself in the movie of the week version of this when it's all over. Hey, I can do it. I can do it. Look at my acting skills.
look, Judge. Yeah, he's gonna tell everybody the whole process and break down how acting
Yeah.
works.
Well, I mean,
Ann Taylor may have a purpose for all of this, and I know she's doing everything she can, and I know that I act dumb and I do stupid things just to it's a strategy, and at the end it's like, gotcha, checkmate.
Mhm. Something like that. Yes.
Something
Correct.
like that. There may be something like that going on here.
Yeah.
Especially when she's making a point to say, oh, I'm not saying anything that Mr. Thompson did anything wrong, because at the end of the day, when it comes out that Mr. Thompson did horribly wrong, she's going to say, well, it's what the evidence showed.
Exactly.
And
That's what I'm saying. Is I'm thinking she's holding back a little bit on.
Yeah, I
on
mean-
certain
Oh
things.
yeah.
Mm-hmm.
Yeah. And Shonda, I called that back in December. I called before that I called the House demo. Then I called you're gonna have Fry retiring, you're gonna have Thompson retiring, you're gonna have the house torn down. I mean, I had the whole order out.
Mhm.
It's just falling into place. The only thing that hasn't happened yet, I even called out Spring retiring in the spring, or Fry retiring in the spring. The only thing that hasn't happened yet, and I'm waiting for it, Dollinger to become the new chief of Moscow. I'm just waiting for it. We'll see.
Mhm.
We'll see. Fuck, this is crazy. It's so predictable.
Well, yeah, I mean,
It's so
know.
predictable. They're all going to scatter.
Well,
Well, I
They're
think
like
Thompson needs
cockroaches.
to. He needs to let go because, from a
Green
prosecution
effect.
point of view, you look at his strategy. It's very evident. He's pulling the same strings every time. It's like we
Yeah,
learn what his strategy is. So somebody needs to take that over and
yeah,
do it a little bit more professional, in my opinion. And I'm not saying he's not professional. He's just overly, I think, took too much on himself. Like,
he's too
enough.
confident.
Yeah. So, the way he talked about, like, the change of venue when he is actually, he has a hard
Arguing
time.
for it.
He has a hard time getting to a point because he's talking about like so many different things, and he confuses people. And then he had a brain fart in the middle of it. So,
Live.
and that sort of doesn't help
Live.
him. And can you imagine when trial comes and he has to be on that side?
Yeah.
And so,
And tactical and
exactly.
and a,
So it's
effective.
probably a good idea that somebody else takes over.
Yeah. He
yeah.
it's comical. It's comical,
And I feel
And-
bad for him. This is his last case. He should go out with a hurrah, right? And instead, he's going to go out a little bit like, meh, a little bit.
Really? No, for real, because you see the issues Ann Taylor's even having with her whole team. You see
Mhm.
Thompson saying, "Look, it's obvious." That's why I'm saying in this court hearing alone, you can see the FBI classified shit going all over the place because of his response and what they're still asking for and what the judge is even talking about. And it's just I when it comes to trial, I don't know. I feel like these experts with what Ann Taylor's still trying to get and the issues that she's having with what she has, I just feel like whether you know about cast data, DNA, or video footage, I feel like these experts are gonna tear up this evidence. And
Mhm.
the juror, it doesn't matter if you know anything about any of it. You're not stupid, and you're gonna see what it is, in front of your face when it comes to these experts, because experts will start, they'll make sense, and when it comes to the facts, when you ask a juror or in front of a jury, if you're asking a witness that's an expert witness about cast data, and you're like, can they be 30 blocks from this location? Yeah. Okay, so this video right here that shows a white vehicle driving on this ring cam, that's my client. Can you tell me that's not my client at the same, a minute after no? Okay, then, boom. You don't have to know cast data. It could be that simple.
Mhm.
It just seems like they waited for all this evidence to materialize because they jumped on it like they jumped on the Oregon car. And unfortunately, in that period of time, it was too late to take your chips back and change it to another bet because you already done put the chips in like you did Oregon. It's just Oregon happened first. What if Koberger happened first and then it was the Oregon car?
Yeah.
Yeah.
I feel like they would have to keep pushing in on it just because they needed somebody to be arrested and charged before students came back.
Mhm.
I feel like this case is going to have a little bit of elements that are similar to the O.J. Simpson case in that, we back then in 95, what was it, 95, 96, something like that, we knew that, like, we knew what DNA was. We had a working knowledge of it. But when it came down to the case and all of the statistics and ins and outs, we didn't understand it like we do now. I think if it was retried with the same stuff, the exact same way right now, we would have a completely different understanding. And some of this stuff, especially like, IgG, terms like that, and touch DNA and all that, we don't really have a good working knowledge. And I think that is going to really cause a lot of snafus in this case.
Yeah, I mean, they could have arrested, they did it. They could have already, you just need probable cause. And what they took obviously was good enough. I'm sure the judge that was signing off on it, before she signed off on it, she said, well, I need more than this. And that's when they added the IgG tip. Because
That's
I
what
think
it's. Yeah. That's what
They
it
were
seems.
trying to push and push, and they're like, "Sorry, we, where's the photo of the car?"
Yeah,
Yeah.
and
Okay,
that
right? Like they
Because
didn't
when
have.
you, yeah, but when you ask CJ, like your normal person, like they're saying from the jury, like the farmer who doesn't want, and you start using words like IGG and cast and all this, and they're going to be like, I don't really know what that means. It's probably going to come down to closer to old fashioned police work. Can you prove to me the car was there? I don't understand all this data stuff. I don't understand this touch DNA. You know, I just have a feeling it's going to cause a big problem.
Well, especially if they jumped on a tip or
yeah.
tips, because they're going to be walking into court with tips and not the work. And ain't no
Right.
jury going to buy that, especially
Yeah.
for a death penalty case. This is somebody's life. It's up.
Right.
Exactly. And
Well,
on top of
what?
that,
Good.
sorry, just a point I want to make, and this is important. I had a friend of mine look at this latest trial with me, who's never heard about this case before, and what he said was,
Mhm.
you know what this feels like? It's like that man is sitting there. This is not the prosecution presenting a case against him. He's there to defend himself, and it
Mhm.
shouldn't be like that. It
Mhm.
feels more like Brian is there to defend himself.
Mhm.
At this moment, that's what this feels like, and it should be the opposite. The
Right.
prosecution is there to present their case, what they have against him, and he should be able to defend himself from that. But this is like an opposite, like we're in a different
No.
loop somehow. It
It's what
feels
they
like
do.
but this is
They
crazy.
put on a that's what they do up there. They put on a bunch of charges and try to get people to plea.
Yeah. So he's sitting there defend, and whether he's guilty or not, we don't know that. Guilty or not, this is like an opposite case. He shouldn't have to sit there and defend himself. It should be the opposite. And that's it. That's all I have to say about that.
Oh, it's a great point. It is.
Yeah.
It's a
And
great point.
he should, as I say, he can be proven guilty. That's fine. But the law and court is how it should work.
Yeah. And in reality, when Ann Taylor was talking about a mitigation witness, and somehow the judge kept saying, well, your mitigation witness, this, that, and the other. The mitigation witness is something completely separate. And I felt like the judge was not understanding that. I don't know if it was just me, but a mitigation expert is in the second phase
Mhm.
of the death penalty. It's the death penalty phase.
Yes.
So the mitigation expert actually goes through a family tree, to present as much evidence about his family and upbringing to mitigate certain circumstances, right? It's to lessen the the sting,
Mhm.
so to speak. So those witnesses, they do a lot of research on the family, and they talk to the family, and like, is there a history of mental illness? They also go through his childhood. And so when the judge was saying, well, your mitigation witness, blah, 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 she says, no, my mitigation witness is completely separate. And I was like, is he even he was like not understanding
Mhm.
that for a moment, I thought, because she said mitigation witness is something separate. She's fine. She's doing her job. She has to do her own IGG investigation, even if it has nothing to do with the IDG as to how they came to Koberger. It's something separate. So what Ann Taylor was asking for is she wants her investigators who have been a part of this case. Ooh. Doggy. Anyway,
No,
she wants her investigators.
Yeah, I heard that too, and
Yeah.
and you're absolutely right about that.
Yeah.
She was confused. Why would he ask that question?
Yeah, I don't get it. So
Yeah.
she just said, I want my investigators who have been working on this case so far to be able to have access to the IGG information.
Mhm.
Because it said her experts could, but the order didn't say whether or not her team could.
Correct.
So I didn't get a response to that. I honestly, I heard the hearing and I didn't understand what happened there.
I think everybody was like, Anne was like, why did you ask that? Even me as a layman in these terms, I understood what a litigation expert is. I know that much. But I think somehow the judge,
Yeah.
I don't know, he had a brain fart. I don't understand it.
They
So I
both
think
did.
she
Yeah.
she was very confused why he would ask that. It
Cocoa
seemed like
Burger
so
Island.
it sort of dropped the bomb on that one. She couldn't make her point almost. But yeah,
I
we can
don't
watch.
know.
I think if
And
we
you know
watch
what?
it,
It's hard because I know that it's pressure and she's under pressure and they're all under pressure. And you always try to think that you could do a good job and but when you have millions of people watching you, I mean, it's like you're gonna mess up.
Mm.
I mean,
yeah,
a little bit.
yeah.
Hmm.
Unless you're like me or CJ.
Yeah. Or
who are like so OCD.
or human. Because we
Or
all do.
I mean, yeah.
Yeah, we all.
I mean, they're gonna say things wrong. I mean, it's like the close, like when you have to go to the bathroom and you gotta go pee, and the closer you get to the toilet, the more you have to go, right?
Yeah.
And so
Yes.
it's like, yeah, we're getting there, and it's like, oh my God, things start slipping. Things start.
The older you get.
Freeze!
I mean, come on. so it's like you. I mean, yeah, and then you have all these people watching.
Yeah.
Anyway,
Well, the judge got one thing going for him. He looks pleasant. He's pleasant to look at least.
well, kind of.
Aww.
Look, he's
But he
handsome. He's
Yeah,
handsome.
well, yeah.
Oh, Judge, you got a crush.
Oh yeah, there's lots of ladies crushing on Judge.
Wow.
Freeze.
I'll be right back because I have to go to the bathroom. So
All right. Well,
I'll
I'll
be
wait
back.
till you
Hold
get
on.
back. Yeah, I'll wait till you get back. We'll go ahead and start watching this.
Just
We'll
stand
see.
Run faster the closer you get.
I know. I
Silky,
can't
you
see
can.
my mouse.
Silky's got her own. The more you know.
Well, CJ, you have to learn something every day too, right?
I do. That's a beautiful part about life. You learn something new every single day. Oh shit! Oh god, you guys crack me up. I love it. Yeah. the peas
Yeah,
instead of the
yeah,
trees.
absolutely. I know somebody said, "Well, dang, now I gotta pee," and I'm like, "I didn't have to." Now I'm
I know.
wondering,
We got to quit talking about it. Everybody's gonna leave the show because they got to go to the bathroom now.
should I take care of that? I don't know.
If I start yawning, I got to mute it so other people don't get tired. It's contagious.
Mm.
Oh shoot. Good stuff. Yeah. So yeah, we're oh gosh. What's up, Carol? Thank you for hopping in. And let me see here. Let me share some links here real quick. If you're not subbed to Silky and Golf here, we got to get a link for Yoli.
It's nice to meet you, Golf. I
yeah.
have never been on with you before, so
Correct. And
Shonda.
I watched you
Shonda.
before. Oh, sorry.
Oh.
I
Oh,
watched
no.
you before here on this show, so
have you?
it's very
Okay.
nice to meet you. Yes, absolutely. Yes.
Yeah, I might have to check you out.
Oh,
Ah,
what is that?
That's
My
your
YouTube?
link.
Oh,
Yeah.
I don't post anything.
You
on
should. I know you don't, but damn it, I'm sharing a link.
Oh, thank you.
Because you deserve it. You do a
Yeah.
lot of you got a lot of good thoughts, theories, and opinions and facts
Aw.
out here, and so I think you deserve it. And let's go ahead and start that too.
Aw,
do
thank
you have a playlist?
Okay,
Like,
I'm
'cause some people on my some of my subscribers, like, they don't do videos, but they have like a playlist on there if you go to their channel, even
Oh
though,
wow,
and they have like great videos. Like,
that's a good
you know,
idea.
yes, it really is. Of other creators, the best.
Yeah,
Mm.
I don't do anything with my channel, but maybe I should. That's a good idea.
Yeah.
And I can
Yeah.
promote other. I mean, people know where I'm at usually when I'm on panels, so I just promote other creators because ultimately that's what I want to do. I want to support everybody in the community, and I mean everybody.
Mhm.
Every
Yeah.
creator.
I do too, and I mean, well, I say most of them. There are some I wouldn't, but it's a very small list that I wouldn't.
Yeah.
CJ, you're right,
That's
Kathy.
funny.
Yeah.
The more you know.
Yeah.
That's why
Well,
I have it up there.
Well, some things you don't know until you get older, and then it's like, oh, surprise! Oh, jeez. That's a great new symptom. Thank you.
My dry eyes.
Yeah.
Jesus.
Oh, all right.
Yeah.
All
Anyway,
right, let's go
okay,
ahead
so
and
what do we
get
do?
into this. We're gonna go ahead and we're gonna dig into this court hearing from yesterday. If you guys want to, what I'm gonna do is we're gonna play both sides a response. We're gonna play both sides a statement response. Then we're gonna pause it, discuss that certain part. That's how we're gonna kind of keep the layout for it. If there is at any time in between there that you want to discuss something about something that they said, just say, hey, can we pause it real quick? And we'll go ahead and pause it and we'll go ahead and discuss it as well. So this is the hearing from yesterday. I'm going to use KTVB7's version just for clarity. So that way it's the clearest possible instead of replaying my stream from yesterday. So this is the episode, and it's an hour and 16. Let me mute the music, and then we'll go ahead and get started in. Like I said, if there's any moment you want me to pause it, just let me know, and we'll go ahead and pause it and discuss it.
Is here in the courtroom. He is represented by Ms. Taylor and Ms. Nassett. Mr. Logston is participating through Zoom. The state is represented by Bill Thompson, Ashley Jennings, Jeff Nye, and Ingrid Beatty. The proceedings, I think they are live streaming through the court's YouTube channel. So please do not attempt to record, film, or transmit during the proceedings. Thank you for that. All right, so we have some motions to address today. And I thought we should first go with the defendant's motion to allow experts and investigators access to view IgG information. If that makes sense, I think also the motion to clarify sealed order for disclosure of IgG and merges into that. So go ahead, Ms. Taylor.
Thank you. Your Honor, reading the state's response, I think the state has no objection to the three named experts having access to the sealed IgG materials or the materials subject to protective order. So I think what we're really talking about is our investigative team for Brian's case to have access to the IgG materials. And the state has objected to that. They've objected in part because they are not named in our motion. So I want to address that first. Your Honor, they are not named, and I can name them, that's not a problem. But the reason I didn't is based on consistency. These same investigators have had access to the grand jury materials to assist us in the case. They've had access to other things subject to protective order, and they're not named in those. They have access, there's three items subject to other protective order, and that's medical information from hospitals, that's University of Idaho records, and most recently, police procedures. They haven't been required to be named in orders in any of those. And so for consistency, I did the same thing. But we can name them if that is a sticking point. I would note that the members of the FBI that did the analysis are not named in the materials either. Your Honor, the reason why our investigators are important to have access to the IgG materials is because of the kind of case this is and the kind of investigation that we're required to launch in the case. We have to have investigators on a death penalty case, and we have them. These materials or these items in the IgG binder, those are things that we may end up filing motions in court. In order to prepare for those, we rely on our investigators to help us with side tasks, with big tasks, with all of the tasks. We would need to utilize our experts. If our investigators can't have access to the materials, they'll have to be shut out of those meetings with those experts, and they'll have to be shut out of court proceedings that we might launch related to those materials. Your Honor, to meet our constitutional duties, in Brian's case, his rights to have effective assistance of counsel, to have a full investigation, to have a fair trial, we have to have investigators. Those investigators are on board and have been on board, and they help us understand things that are given to us by the state. They help us find witnesses, they help us find experts, and they're necessary to be part of the conversation of what the IGG materials are and what they mean. This matters in figuring out how Mr. Koberger ends up on the police radar and subject to these proceedings here. I know we've talked about this before, and I still don't have all of those answers. I believe today, with our experts getting access, we're going to make some headway with that, but we also need our investigators to be part of those discussions as well. Again, Your Honor, if their names appearing in a court order is an issue, that we'll do that. We'll do that. That's inconsistent with the other protective orders, but we'll do that. And they'll be subject to the protective order just like we are, and they'll abide by it just like they've done for the other protected materials they've had access to. And while we're on that line, if the court wants me to talk about the clarification, I can do that.
Let's hear from the state first. I mean, I understand the having investigators. I think what we're talking about though is just with the IGG that we have to be especially careful about, you know, who's going to have the access, what they're going to do with it. I think I agree. It's clear that the state has no objection to the three experts that you've named. So I don't think that's a problem. But let me go to Ms. Jennings.
Yes, Your Honor.
Thank you.
That's correct, Your Honor. And Your Honor is familiar and aware of the materials that we're discussing, and you're also aware of the sensitive nature of those materials. The state is really just following the court's lead in your protective order, where you named specifically who on the defense team would be allowed to have access. It follows that if we're going to expand that access, that those individuals need to be specifically named. And it's really going to be the only way the court can have control of any unauthorized dissemination, is to know exactly who was privy to what was enclosed. So at a bare minimum, we need to know who it's going to be given over to. Your December 29th sealed order also said that any further dissemination of the materials or the information contained within the materials, including to any investigator or experts, must be approved by the court after a showing by the defense as to why such individual needs the information. In the defense's motion, their stated reasoning is, quote, to investigate how and when Mr. Koberger was identified as a suspect, end quote. State maintains they don't need access to all of that highly sensitive information. To satisfy that purpose that is laid out in the November 28, 2023 letter from the FBI to the state. So we would ask that one, they be named. If they are granted access, that it be to that letter, and that the balance of the materials be protected. And we would ask that you follow the proposed language in the state's response from February 9th to ensure further protections of the materials.
Thank you, Ms. Jennings. Sailor?
Well, Your Honor, I know what letter Ms. Jennings refers to, and I think our experts should have access to the actual materials. That letter is a summary. It's a police summary. Our duty is to investigate police work. We do that in every case, and with our heightened duties in a death penalty case, our investigators should have access to the entire record. Our investigators understand what a protective order is, and they'll abide by that protective order. Again, if you want them named in any order allowing them access, that's fine. That's just fine with me. It's most important that they have access to all of the materials. The summary contained in the FBI's letter isn't the totality of the materials. It doesn't show some of the particulars about things that were happening on certain dates. And that's what's important to put into a timeline so that we can try to understand how the state did its work in this case.
Well, one of the issues with this IGP is relevance at all. And so the way I'm viewing it is it needs to go on steps, maybe where it's justified with the relevance or the potential of relevance for some of that information, because from the very beginning, the state's position has been it has no bearing on the case. It will not have any bearing on trial. But I allowed the access to what I thought was potentially relevant, and to allow your experts, now allowing your experts to view that information. So let me just kind of move into the other clarification.
All right, so we'll go ahead and stop right there, and we'll go ahead and discuss that part. There's a few things that I wrote down just from listening to it again, but I'll let you guys go ahead and let me know what you thought of that first exchange there. Of course, they're not, being named in this one. And Taylor's like, it's perfectly fine. We can do that. We're not trying to hide anything, which then you hear dissemination, which is, it means spreading something. So that whole thing, what are you trying to spread? I don't think the defense is going to let anything slip because it wouldn't be to their benefit. Wouldn't be admissible. Highly sensitive info. It smells FBI. That's why they don't have it. That's why I'm saying tip. They talk about another tip. Look at the letter. It's a tip. Look at the letter. That's where we got our stuff. And then, like he's saying, the IGG, is there any relevance at all regarding what you're asking for? Because he probably didn't even get the information. And so he's like, why are you trying to bark up my tree when it's the FBI?
Yeah. And typically Unique asked if you could see the hyaloid bone on an x-ray. I don't see why you wouldn't. If they take it properly, you should be able to.
To see the highlights? Sorry, I don't think I heard that.
The
Oh.
hyaloid bone in the neck.
Okay.
I would think so. I guess maybe they're wondering if there is a different kind, maybe a wound that was prior to the fatal one.
Right.
Oh,
Like-
okay.
like a suffocation type wound.
Oh, I see.
Yeah.
What you mean. Yeah.
Yeah. I didn't know how to say that. Thank you, CJ.
Okay, I got it. All right.
I think you're on mute if you're trying to talk, Yoli.
No, I wasn't trying to talk.
Okay. No, I saw you were typing in chat about the medical records.
Yeah. I just thought, like when it comes to medical records, and she's trying to get, if I understood correctly, she's trying to get medical records from the prosecution. And of course, she doesn't say whose medical records, right? So people are assuming that it's the victims. But I thought that the only medical records that the prosecution would be able to have legally without violating HIPAA would be those that occur during the job of an officer. Because, they're still covered under HIPAA, but because it's a work injury, they may have medical records that show some injuries, and maybe she's trying to get that information.
I
don't
wonder
know.
what what
Um,
kind of injuries the officers would have had, you know?
if they had injuries. I mean, I don't know.
But I
But
mean,
I'm just trying to work backwards and think, okay, so x-rays, are x-rays usually taken in an autopsy? I've not seen that, but it's not.
are they Silky? Silky's
I
a nurse.
yeah, I mean, I don't know in an autopsy though.
Yeah.
I
Nobody will
heard
let me perform one. I'd like to.
I heard
Oh,
lawyers discuss this, and
whew.
it's common in murder cases
Mhm,
that they do X-rays. It's not
okay.
uncommon at all.
See the severity of the injuries, probably specifically in the injuries that they had. I would imagine
Hmm.
that would be probably one of the cases or types of deaths where they do go into the
Hmm.
X-ray because it probably does. You can only tell something from the skin. You really do need to look at probably the bones as well, because usually that's what
Mhm.
stops whatever the weapon is.
Yeah,
Um,
that makes
so
sense.
going to
That
the
makes
medical
sense.
records, is there any way that they could be talking about Brian's?
See, I wondered that, but then I thought, wouldn't Ann Taylor have access to that? Because
Sure,
that was my thought, wondering
she
if
would.
he had an injury.
Yeah,
Uh,
but she would. But then what I think she's looking for
Yeah,
is what
she
they
has.
have. So basically, like, what
So
kind of medical records do you have on my client? But she's not saying that, right?
oh, that's true. That's
Yeah.
true. Yeah, I was thinking that same thing because what if he says that he had like a hand injury or something and it would be impossible to, commit this kind of crime?
Oh, Silky, damn.
but that would be something that Ann Taylor would have investigated on her own, and she would have been able to get a HIPAA release from her client to get it. So she wouldn't be
Sure.
asking it of the
No, she would
prosecution,
be
right?
asking what they have. So
Yeah,
basically, what law
Yeah.
enforcement
What
has.
did you get?
What
Yeah,
did
what
you?
did
So
you
did
get?
you
Mhm.
do that? And I want to know if you
That's
did
possible.
on
Yeah.
my client. Like, she's not saying it, but that was my first thought. But I could be totally off on
Hmm.
this one. It's
Like
just something
mental
that
health
hit me.
record.
Correct.
Right,
Mental
like mental
health
health.
or
Because they
something
they
else.
did reference the questionnaire that BK was using
Hmm.
when it came. Yeah, that's true. Maybe it is.
Hmm.
Maybe they're stating that there's some kind of mental health records that was associated with that survey that they were using in reference to, because they used
yeah.
it in the PCA as a reference.
See, I could see it either
That's
way, mental health records or physical records. And
Mhm.
and I could see her asking, like, even if it was a physical injury, I could see her asking, like, basically what you said,
right.
golf inspector,
Hmm.
is like, do you know what I know that he's got an injury?
That's
Or,
crazy.
Hmm.
Because what if remember everybody was talking about that picture in the body cam where there was that part on his right hand that was, remember, it was, is this an injury from the crime? Maybe that is an injury that took place prior to the crime that he was getting help for, which would have made him unable to hold a knife or something like that.
yeah.
Whoa, Silky, I never thought about that.
Yes.
Damn.
I mean, I don't know if
And
it's
then
true.
that makes
I don't
sense.
know if,
'Cause
yeah.
what if that was an injury? Because to me, when we were looking at that picture back then, I'm sitting there going, if it is something, it looks like it's older,
Hmm.
Yeah. Yeah.
And yeah,
Makes sense.
it looks like it's older, and I don't know if there was ever a determination whether it was a reflection of something or if it was actually, an injury. But yeah, that could be that he had a previous injury to his right hand.
Hmm.
And that
And
would
that
be
right hand, if he's
exculpatory.
right-handed,
Like,
Well, if
Yeah.
he's
yeah,
yes, if
right-handed,
he's
correct. Yeah,
right-handed,
exactly.
right. If you're
yeah, like an old
right-handed
surgery.
Yeah.
and you can't grip a knife,
Yes,
Mhm.
that
you're
would be,
you're
yeah.
you're so solid on this crime happening from a knife,
Hmm.
but maybe you couldn't grip it.
Hmm.
Dang,
Exactly.
what a
Well,
great.
Yeah. And then they would be then holding on to exculpatory evidence, which would be a huge problem.
Ooh.
But see,
But
couldn't
that
Ann
would be
Taylor
better.
get that? get those medical records.
Yes, she
Right.
would, but she doesn't know what
Right.
the police has. And that's my
Right.
my point was like, okay, she's asking because of the police, like what do you have
Yeah.
on him? And they might have not want to disclose that. So I don't know.
Right.
This is just something that when I was watching it, and I
It's
don't know
true.
why I got that impression, but when I was
Mhm.
watching it, I was thinking the whole time they're discussing Brian's health
Mm.
records, right?
Maybe they
Well-
don't want to disclose it because they don't want to disclose a whole bunch of other stuff too that is contradictory to what the hell the PCA even states.
Yeah. But now don't
Yeah.
run with this, people. This is just
No.
this is just a thought, okay? So
Well,
don't run
Yeah,
with
just
it.
a thought. Exactly.
And
It'll be,
Yeah. We don't
Here's the-
know.
Yeah. Here's
it'll
the
be
other-
on somebody's show
No
tomorrow.
whammy, no whammy, no whammy.
This is what they're saying at CJ's. No. They're just discussing it as an option because obviously the name is not coming out. She's
Right.
not naming
Right.
names. So we just want to throw out possibilities. So
Oh,
not
yes.
speculation.
So
Yeah, it's
here's what,
speculation to a degree. But
Right there, down at the bottom.
Yeah.
Speculation.
Okay, so here's what I thought. They did take portions of the house. They cut out walls from Maddie's room,
yes.
and I did some research, and I'm going to post it in the Discord file. One of the only reasons why they do that is that if there were bullet fragments in the wall, and it's in a forensics manual that I saw. And so I just wanted to bring that up because
You cut out there. Hold on, Yoli. You cut out on. You said the only reason they would do that is. Then you cut out. Can you repeat that one more time?
the only reason they would do that is if there were bullets in
Okay.
the wall,
If there were some-
and there's bullets in
Okay.
the wall. Yeah. So there's a forensics manual that talks about what you do when there's bullets inside the wall that you don't want to try and take them out. You just cut out the wall.
So you wouldn't do that if you had blood.
blood? Yeah, I would.
Well, I didn't see anything about blood.
That's what I thought because
That's what I thought.
they took floor and wall. That's
too.
why I said the slumber party.
I didn't see anything about blood. I did see something about blood splatter. I did see something about blood splatter, but usually they don't cut the wall for that. They use these.
I think they were trying to find
strings.
DNA. They didn't have it.
They use strings for the blood splatter.
Mm-hmm.
They do all this complicated,
Oh, I'm saying for future I'm saying they took the walls and the floor because they didn't have any DNA other than what was on the inside of the button snap, and they needed to try and find every freaking source of
possible.
DNA they could
Yeah.
try and find, and that's why I think they took the walls and the floors.
That's
Yeah,
possible.
they probably took that shoe print that they found.
Yeah.
Yeah.
But I'll
can
put it-
imagine.
Second
I'll
time,
put-
the second
Yeah.
time they came through.
They're like, oh, we better take this. We better
Yeah.
take, take the whole.
Let me flip on the blue light. Oh my God, there's a footprint. Holy shit!
They'll probably
Yeah.
show it at trial.
job,
here,
boys.
Here it is.
Good
Look
job,
at this piece of the flooring. I mean,
Good job, boys.
Yeah, so I'll put what I found in the
Tell
Discord
everybody
file.
he had a Bissell backpack.
Oh,
Yeah, Bissell. I'm familiar
Bissell
with the Bissells.
backpack. You know, he saw that footprint, he just went right before he left.
No, I'll put it in the chat. It's interesting because that's one of the reasons they say that
You're
that's
gonna
done.
call.
And you hear these things, and people say, the initial report, the parents got was a shooting or something like that. And you wonder, and so I'll just put what I found on the internet. It's a forensics investigative manual of how you're supposed to process evidence.
Mhm.
And it's a website, and I'll just post it in the Discord so you all can look at it.
Okay. Yeah, and then when you post it, I'll go ahead and copy it and post
Yeah.
it in here too. So
Yeah, because it's something to think about because you did have initially the family getting reports that there was a shooting. They were shot.
Yeah, but it's a
which-
game of telephone,
It is, but they did take the walls.
yeah.
Yeah. If you're not part of the Discord group, go ahead and click that link if you're on Discord and you can be a part of the conversation. Plus, we have all new info drop folders. So, all the hard work you all do out there, if it's for a certain case, drop it in the info drop folder. If not, drop it in the breaking news and we will get to them a lot more efficiently, too. What's up, Crime Lies? Ticket 77. All right, let's go ahead and we're going to get into the next part. And if you're just hopping in, you're gonna want to go back all the way to the beginning. We had a great conversation before we started getting into this too. Thank you everybody for hanging out on panel. Thank you
Now I
everybody
have
for hanging out in
now I
chat.
have to take my dog pee, so you don't have to wait. You don't have to wait. You have two
Jeez.
females.
I don't even have a screen ready for the peas yet. All right, I
This
just
time it's
have
my dog.
freeze. I don't.
We're both
have peas
females,
yet.
so
Yes.
That's right.
anyway, I'll be right back.
Thank you everybody. I appreciate you.
Location, because I also understand, particularly relevance of mitigation. Okay, what your investigators need to cover. They likely have to have contact with Mr. Kogelberg's family, and that we're not. I don't think we're talking about that kind of investigation. I mean, that is your responsibility. It's also your responsibility to dig in wherever you have to. I mean, I think you're required to do that. So my balancing responsibility is to keep it in control to some degree. So I guess what I'm asking is that I have some justification for making contact with certain families that may have no bearing whatsoever on the case, unless it's in mitigation or something like that. Now, the DNA issues, maybe especially in the IgG, it has to have some relevance if there's some context, okay, that connects to the case itself. That's how I'm looking at it. I might be wrong, but so you can respond. Okay.
All right, we're talking about a couple of different things here. With our request for clarification, I was talking specifically about people that are already known to our team that we may be in contact with. Brian's direct family, parents, sisters, aunts and uncles.
And
Those
can
are-
I interrupt you just for one
Sure.
second? That has no relevance to the IgG information that you were given.
Those are people we already knew before.
Okay.
So I want clarification that I can continue to talk to the Koberger family.
Yes.
I want to make sure I'm not running afoul of court order.
I
want to
absolutely
be
appropriate.
I want to be really clear who I'm asking for to have access to the IgGs. It's not our mitigation investigator. That our mitigation investigator, I think the court heard me talk about going 3 generations back to do her work. That's required under the AVN. I'm not talking about her. She wouldn't have access to this. I'm talking about our criminal investigators dealing with the innocence space for Brian. Those are the people that I think should have access to the same materials under the same protective order. They're not doing the generations back. None of the IgG materials would be used for that part of the mitigation work. She's doing her own thing, our mitigation investigator, looking backwards as she's supposed to at the things she needs to. That's not the IgG materials. So putting aside that investigator and thinking of only our criminal investigators that are going to be dealing with our innocent space of the case. Those are the investigators that I'd like to have access. They're the investigators that participate in the meeting with our experts. They're the investigators that help us put the timeline together to understand different things that were happening in the case before Brian's name was ever spoken by anybody. And we're missing that big piece about why was Brian's name spoken and how does that connect to the other pieces that we have. That's what our criminal investigators are going to do. They're not looking at IgG materials, if allowed, to do any of the mitigation work. That's separate and apart. So I want to make sure that that's really clear. Also, when we're talking about whether something is relevant or not, I think that we're thinking of the standard for information to come out in court. That's not what I'm talking about. The court found that the IgG information was material under the discovery rules to the defense and allowed us to have access to some. It's for that same purpose and under that same rule that we're asking the court to allow our investigators to have access to the same materials. Whether or not any of this is something that comes into the court or into trial, that's a question to be answered later. I can see how, I think, this is why I'm really happy to have our experts involved, but I can see a way that there may be a motion practice that happens that relates to this. I'm not there yet.
That's where I'm because if you have these experts, okay, go through this. I've been through all this information, and so if you can go, using your experts, and your experts kind of can tell me and the state that you need to investigate particular people, okay, that were involved in this, then we can have a hearing about it. But I'm not quite ready to be convinced that without getting this information from the experts that we're gonna find some pathway, okay, that's going to be helpful to Mr. Coburn.
If I mean, so
I don't know.
Courtroom. So if that's what you want to do, we can. I'm here. We waited a while to come to this hearing. I'm asking for it all with a protective order. If we do it the other way, we can do it. It's just everything takes time. And if that's the preference, that's okay. The court knows and would order us to not reach out to any of the people in this material, and we wouldn't do any of that. If we have a motion to file that references any of the content of the materials, that would be filed under seal. These are sealed items. If there was a hearing, I would guess the court would have a chance to look at the filings before granting me a hearing and hear from the state, and that would be sealed. I'm not asking our investigators have access to run out and start interviewing people. I'm asking they have access to not be shut out of conversations, considering what this means and how our client came to the attention of law enforcement, and to plug things into the timeline of us trying to understand how we got from November 13th to December 29th. That's it, not to go out and try to talk to people. I can just see that there's a potential motion to be filed, but that wouldn't be contacting anybody at all. That would be a motion for the court.
That's reassuring. I mean, that's one of the concerns. I mean, pulling a lot of other people into the case that, are completely innocent and don't even have any connection to the situation. So let me go back to Ms. Jennings. Do you have any response to any of this?
Can you pause?
No, Your Honor, I'll just reiterate that.
Yeah, go ahead.
Did you hear what she said? She said
Which
November
part? I took
13th.
notes. Yeah.
Yes. So
To the-
basically, they had Brian on November 13th.
I don't know if she's saying that. I feel like she's saying, how did you get from him from when the crime took place until you were getting ready to arrest him? Like, I don't see the connection.
You don't? Okay.
Yeah,
I might
that's-
misunderstand that, but I just heard like from November 13th, she was talking specifically about the timeline on how they got to Brian.
Yeah.
So she wasn't mentioning like the timeline of the crime, but how they got to Brian.
Yeah. How'd you
So-
like your IgG info ain't showing me. Your cast data that you've given to me that I need more of ain't showing me. The video footage I'm going through ain't showing me. So how did you get to him in the first place? And I think what she's trying to do is she's trying to make this IgG information become the crutch.
Mm-hmm.
I think is how I took it. What'd you
Yeah.
guys?
I could be totally wrong here. I just like
No, I mean it's a
that
good.
that sort of stuck out. I was like, hold on.
It is a good point. I wrote it down kind of like I'm not
Mm-hmm.
asking to find out who the DNA is. I'm not
Mm-hmm.
asking to find out how you matched him up. We're already talking to the family. You're okay
Yeah.
with that, Judge.
Mm-hmm.
I just want to find out how you got to him
Yeah.
because I don't see it.
And that's where the investigators would come in if they had access to the information. Not, I mean, I feel like Judge thinks that she's going to have her investigators go talk to all these people that are involved in the IGG or something, but that's not what she's asking for. She wants her investigators to have access to the IGG data in terms of timelines, like, when they got it, what they did with it, and things like that. It's not that, and for some reason, the judge seems to think that she wants her investigators to go talk to people, and that's not what she's talking about.
Mm-hmm.
Well, I think she realized the grand jury and reversal probably won't work. And I think she's pushing on this now because really, it's like I've always said: if you don't have the DNA, you ain't got the PCA. And if you're just talking about a tip, she's like, "Yeah, we got the tip. I see the stuff that you sent us. It's incomplete work because you just gave us ISP and Orthram. We don't have what took place after that. So when I'm looking at all the stuff, this box of unorganized stuff that you gave me, prosecution, I the last court hearing I told you how hard my whole team is working just to try and understand how you even got to Koberger's name, and we can't even figure it out. And so it's like, okay, the video's not working, the cast data's not working. It's got to be the IGG because the IGG is the only way that you came up with my client's name in the first place.
Mm-hmm.
Other than that, before the IGG, you were a pool full of 2011 to 2013 Hyundai Elantras before you got the name from the FBI. And I don't know. I feel like why would the judge be concerned that she's going to go out and interview people that she finds out is on IGG? Why would he be concerned? Is that why the prosecution was saying that they're afraid of dissemination, that the the defense is going to spread something by going to talk to these people? Like,
Right.
I don't even understand that.
I don't
think
understand it. I don't either.
I don't think she would be that reckless. And then that's
No,
almost like you're questioning her character and her credibility when it comes to her accomplishments.
yeah. That's it's
Kind
strange.
of like how we talked to her in the last court hearing when it came to, you can go talk to the Supreme Court if you want to, but I wouldn't suggest it. Like she's like, it's not good that she's questioning what he's doing in the courtroom. I don't know. I think shit needs to be questioned because it doesn't look like he ever wants to make a decision. It does. I mean, it's fine if you don't understand cast data and all that other stuff. Who does? But when it comes to like putting the ball up to the prosecution and being like, yo, when you're setting deadlines for having all the information, why if the judge was privy to all this information that he was supposed to get on December 1st, why is he not saying, okay, well, it's like he's kind of saying it a little bit ago. He's like, what is the relevance to the IGG information when the prosecution says that they're not even going to use it?
Correct.
Yeah. And the problem with that, it overlooks the fact that the IGG is in the PCA, and that IGG was persuasive to a judge in Pennsylvania to find probable cause. So that whole thing is missing. He's basically saying Well, if you're not going to use it in trial, then you're not going to use it in trial. But they used it for the probable cause.
They
Mhm.
covered their asses. Pennsylvania and Washington covered their asses in their PCAs.
I
They're
mean,
like, look, the only reason we're doing what we're doing is because Idaho gave us this. Both of them said that shit
Yeah.
in their PCA because they know it's shoddy ass shit. And they're like, look, don't come back up. Don't blame us
yeah,
for something, you know,
it's like we're
because it's that Christmas stocking full of fucking crumpled up paper that they walk around and they tell everybody, look, it's full of Kit Kats and Hot Wheels.
like
Uh,
I wish that Ann Taylor would have. Well, I don't know. I just would think that maybe Ann Taylor should have said the IGG is in the PCA. The PCA is the probable cause affidavit.
Mhm.
Therefore, we are entitled to the IGG because if it's flawed and it's wrong, then that means there's no PCA.
Watch
Yeah.
him get off. Watch him get off because, just like in other cases, history repeats itself. Watch him get off because they can't supply the technologies and practices and homework for them being able to get the tip for the prosecution to charge somebody a DP based off of a piece of paper that says Brian Christopher Koberger on it. Sorry, you're gonna lose that battle. And the IGG, it's it's gonna have the least amount in the court, but man, like how else are you supposed to convict somebody of a DP when you just have a tip? And that's why they're saying we're not using the IGG because we just got the tip. Unfortunately, they probably thought, just like they always do, we're going to throw a bunch of charges. We're going to throw this DP at Koberger, and hopefully he'll plead to something lesser. It didn't work. Ann Taylor's on the scene, and she's going to make sure that he don't get compromised in any way. I mean, hell, Koberger was agreeing to keep some shit sealed because the prosecution was asking him to.
Mm-hmm.
What the hell? What the
Wow.
hell?
Yeah.
Yeah. That's why
It's
they're
very
like,
strange.
you know what?
All this whole thing is strange.
That's why I felt like they were like giving the prosecution team, and Taylor was giving them 150, and they're like sitting there going, you know, it's like why do they want, you know, Banfield? You can't have it both ways, Koberger. Well, you know what? They probably said, you know what? We're tired of giving you 150, prosecution. Come on.
Actually, he can have it both ways if he agrees.
Yeah, you can.
If
But
he
Banfield-
disagrees to the gag order, I mean, I don't know.
Banfield didn't think so, and
Yeah,
it's like, come on. Koberger's like probably like, yo, I've been bending over backwards to try and help this shit move along, so my attorney can get what she's asking for. So we're doing extra just so you'll give it to us, and they finally got enough of the gaslighting as well, and they're like, fuck it, let's just have it unsealed.
Well, I think a lot of the PCA was cast data, right? A big portion of it.
All of it.
Is that right or wrong? Most of it, yeah.
She's
So
asking
that's what she's asking. But I mean, the PCA had things in it, and one of the things that was a big part was the cast data, right?
Yeah, it's all of it. Cast data, video,
Uh-huh.
IGG information.
Yeah.
But the problem with the cast data is, if you read the PCA, it says that the detective consulted the FBI on it. Not that they did it, that he consulted the FBI on that, and that he did the work. Doesn't it say that in the PCA verbatim that he consulted the FBI? Because now it sounds like the FBI did the cast data.
I'm not, you know.
I think they did, yeah.
Yeah, but if
They-
if you read the PCA, doesn't it say that he just consulted the FBI?
Let me see what page, and I'll go right.
Oh
to
my
it.
goodness, I cannot remember.
Anybody know what page it is? I'll go right to it.
Yeah, I mean that's important
Just do a word search for
yeah,
CAS.
because
Consultant.
I don't think it even says CAS. It's talking about the, you know, if you look, yeah. Oh God, I can't remember where it says it.
Well, we can get back to it. I'm going to play this some more
Yeah.
and I'm going to make a note, and then somebody in chat, let me know what page it is and we'll get to it when we hit the next pause. Please hit the like if you haven't yet. It's a free way.
Mm-hmm.
And if you've missed this, if you're just hopping in, trust me, you're going to want to replay from the beginning. We had a great conversation before we started getting into this. So here we go. Here's the next part.
Ms. Taylor keeps discussing their ability to just understand the timeline. Again, you're very familiar with the materials. Understanding the timeline and how we got from November 13th to December 29th is all laid out in that letter. None of the other materials are going to answer their questions regarding the timeline. So ask that they be given access to that, named investigators to that letter.
Thank you. You may remember a few hearings in the past that the state, from the very beginning, said there was no, that played no no, I don't know how to even, it wasn't, when I asked them in the hearing that, did you use the IDG, any of the information of the IDG to get the warrant, to get Mr. Koberger's DNA, that was not part of it. So in terms of the time frame, don't know that it's that complicated, because a lot of what happened in the time frame happened before that. Now, that's up to you to dig into that, obviously, but there was a lot of information in the letter too, just their sequence of using the IgG at all. So we're going to have to sort this out, obviously. But going back to what I'd like to do is just get some justification for digging in deeper, if necessary. And I'm not sure it's necessary, but I'm going to keep an open mind about that. So for right now, I would say, let's just get your experts looking at the IgG stuff and exactly what they can read from that. And we'll go from there. Okay. Now, with regard to your clarification, yeah, I mean, I'm not saying that your investigators can't contact people that they've already contacted without relying on the IgG information. That work for now?
Yes, Your Honor. Our mitigation expert has done her own family tree based on her work, and she has nothing to do with the IgG material. She's not an expert that would have access to that. She's not named. So she needs to keep doing what she's doing as far as her work goes. And I think the proper clarification is that the IgG materials will not be used to develop any investigative leads.
I think that's fair. And what Ms. Jennings proposed in language in their response to your motion, is that something that you would object to at this point? I'm sure she probably read that language.
I did read it. It's a little bit less straightforward, but I think it covers it. It allows me to continue to speak to the people I'm speaking to and that I need to speak to that are on my list.
Okay. Anything else about that?
No.
These issues. Okay. Ms. Jennings?
No.
Okay, great. Okay, the next question I had is, I know that Mr. Koberger filed for permissive appeal to the Supreme Court. And I just wondered what you know about that, because I have heard nothing about that. I know it was filed.
I know the state filed their objection, and that's the last that I recall seeing about it.
Yes. So at this point, we don't know if the Supreme Court is going to take it. Okay, we don't know that. You know anything else, Mr. Thompson?
Not other than the state's response was filed by the appellate division of the Attorney General's office. And I think we're just waiting to hear from the Supreme Court at this point.
Correct, Your Honor. We're just waiting to hear from the Supreme Court. I can tell you there's no deadline in the rule for them. They didn't include a deadline for themselves. And in my experience, it can take anywhere from a couple weeks to a month or so. So at this point, we're just waiting to hear.
So I don't know the answer to this. If it's filed, does that pause what we need to do here, or do we just pause it only when they pick it up?
My read of the rules, Your Honor, is the latter, that we continue as we are unless and until they decide to take it, and then they would decide at that point what exactly is paused and not paused.
Okay, thank you. Anything else about that, Ms. Taylor?
No, thank you, Chair.
Mr. Thompson?
No, sir.
All right, I think we're now to schedule. Starting with, there was a request on change of venue, maybe late April, you were saying.
Yes, Your Honor, either that last week of April, I think it starts the 29th and 30th, or the first or second week of May for the actual hearing is when we'd request. And we would ask that we have until maybe the second week of April to get our initial briefing in, and then the state's response and our reply after that.
So what are you thinking would be the hearing? Like, give me a day or a week.
I would say that first full week of May, maybe that's May 5th or May 6th.
Yeah. All right, thank you. Okay. Ms. Beatty, Ben? Right.
Your Honor, we're asking the court to either deny this motion for change of venue as premature, or to set a hearing date closer to the trial date when that trial date gets set. And the reason for that is when courts look to change of venue and whether or not that's appropriate, the courts look to affidavits that have been filed. Importantly, they look to what jurors say, prospective jurors say during the voir dire process. Another thing that courts look to is the amount of media coverage and the proximity of that media coverage and the intensity of that media coverage to the trial. So in this case, I think we don't have sufficient information to even determine whether or not that's appropriate without seeing what prospective jurors actually say. But B, we're far enough out from trial that we can't really gauge that anyway. So we would ask the court to either deny that motion at this time or to set a hearing further down the road and closer to trial. If we do proceed to hearing, the state would just ask for a scheduling order. At this point, the defense has filed a motion. They did not file any affidavits, disclose any experts. They haven't even filed a supporting memorandum. And so we're not even sure what specific cases they're relying upon. So we can't really respond substantively to that motion until it's briefed. So we would ask the court to set a briefing schedule as well. Thank you, Your Honor.
Okay, thank you. Well, my interpretation was that they were going to give us a lot of information, affidavits, maybe testimony for the hearing. Is that right, Ms. Taylor?
Your Honor, you're right. The motion was to put everybody on notice that we'd like to have this addressed. We do intend to have a presentation for the court. We do intend to have briefing for the state. I anticipated we'd get that scheduled today. But no, I didn't file the motion. I filed it to put everybody on notice that it's coming, and I think we need to address it. I think we need to address it before a trial setting. It doesn't make sense to set a trial, get right up to it, and then have to have everybody who's under subpoena rescheduled and have to have the public and the families of everybody disappointed because we're going to reset it at the last minute. So I think we should take care of whether or not the court should change venue sooner rather than later, especially given the length that this trial is anticipated to go. We'll need to schedule a courtroom either here or in another county in Idaho. I mean, we'll need some advance notice to get that done because it'll take a long time to try this case.
Thank you, Ms. Beatty. Thank you, Ms. Beatty.
And Your Honor, the state is asking for a briefing schedule so that we're not in a situation where the state is learning for the first time during a hearing what experts the defendant might be calling and what their arguments are. We would ask that all of that information be disclosed prior to hearing, including the CVs of any experts that will be testifying.
Well, that's certainly what I would expect. But it's quite sticky, right? To think, you're going to wait until ready to seating the jury, which is probably a 2-week process in this case. And then figure out, hey, we can't seat a jury, so we have to move the trial. At the same time, how do you really know if there's some prejudice without trying to seat a jury? It's really a catch-22.
And all of the logistical concerns that Ms. Taylor is describing are totally correct. The problem is that is what the law requires, and that is what the case law says. The case law does contemplate that. So certainly it's correct to note that there are going to be logistical challenges to that, but that's what the case law requires. But even if the court weren't inclined to wait until we're actually going through the voir dire process, at a minimum, I think it would be appropriate for the court to look to some jury questionnaires and at least go through that process.
Okay. This morning I was looking at State versus Haddon, where that was, you're probably very familiar with that, but that's Court of Appeals case, 2012, I believe. And there was a request to change venue well before the trial. The judge denied that, and then it came up again when they were trying to seat the jury, and then the judge denied that at that point. But kind of a double step to figure out if it was necessary. I've been struggling with this, for months, and so it's hard to know. Now, that doesn't mean that one of the parties can't present evidence, and the standard is kind of squishy, in my opinion, but they can provide that kind of information well before the trial. At the same time, I want to make sure that the state has the opportunity to respond to whatever information the Mr. Kohlberger is going to present. So now I'm scratching my head about, is May, first week of May, does that allow enough time? Does that allow it enough time for you, Ms. Taylor?
Your Honor, I think it does. I can present the information to the state. I can have my briefing and I can have affidavits and let them know of any witness that I want to call. I can do that probably by the beginning of the second week of April. And that would give them, if we do this in May, that would give them ample time to read it over and respond to what we intend to present.
Thank you. Ms. Beatty, what are your thoughts?
Your Honor, as far as the duration of time between the briefing and the hearing, the state has no concerns about that. The state would just have concerns about those factors that the courts require us to look to as far as the timing of the hearing compared to the timing of trial. But as far as a briefing schedule prior to the hearing itself, that timeline makes sense to the state.
Well, let's explore that just for a moment. Because I've been thinking about the setting of trial. also for months, but I listened very carefully to Ms. Taylor and Mr. Thompson in our last hearing, and I really, it wasn't clear that I'm not really happy about setting the trial in 2025. It seems so far away. Now, it's not just, doesn't just affect Mr. Koberger and his defense, but there's a lot of other considerations. So I am trying to be fair and realistic, okay, about when we could really be ready for trial. Now we want to do it once, okay? So let me go first to you, Mr. Thompson, about when. I know that it's been complicated, the discovery. I mean, you have these different agencies, FBI, state police, the state lab. We've got Moscow Police Department, Latah County, Pullman Law Enforcement, Pennsylvania Law Enforcement. And I think you mentioned it's hard to get all this stuff together. And that is one of the things that has delayed setting the trial, not to mention the motions about the grand jury procedures, also the issues about the investigative genetic genealogy issues. And I'm kind of curious, okay, when do you think that you will be completely finished with providing discovery to the defense?
Judge, most current projection that we have would probably be at the end of this summer. The majority of the discovery has been provided. That's not to say that Mr. Koberger has been able to, and his defense team been able to digest it all, because it is substantial as an understatement. We are still awaiting information that the defense both wants and needs to have, and we're going back through all of the discovery to make sure that nothing's been overlooked. We have two members of our team, an attorney and a legal assistant, who are essentially assigned full time to that task. And that's projecting we got from them. It could be up to 6 months, which would put us with initial discovery completion at the end of August, 1st of September of this year.
Because last time you were talking about August for the trial.
Sure enough. And that's what we had hoped for. And when we filed our motion for trial setting scheduler back in December, a couple months ago, we felt that was realistic. And as we are looking at where we are right now, I'm not sure that it is. We know that the defense has already indicated that just on the death penalty alone, they will be filing multiple motions, and they've been very lengthy. We've seen the same filings in the Nez Perce County homicide case that recently resolved. Those I could see taking a couple months in and of themselves to address, in addition to motions that actually directly relate to the merits of this trial, discovery, motions of limine, and that sort of thing. Our team met again this morning with our companions from the AG's office here in Moscow, and we actually have a proposal to make to the court for a trial date and a scheduling order, if Your Honor is interested.
I'm very interested. I'll tell you before you
Can we pause?
say anything about that.
I was just gonna pause it.
What did he say? We just had a meeting this morning with
Yeah.
who? Yeah, who did he
Yeah,
have a
you know
meeting
why?
with? Yeah.
Oh, he had a meeting that he didn't have a real meeting, Golf. He had one of those fake meetings that says, "Son of a bitch, we're getting backed into a corner." Yeah, we had a meeting, and we were going to propose something for the court here.
Yeah,
We're
no.
gonna-
Out of interest though, because he does mention we had a meeting, and he doesn't want to say with who really. Oh, with. But the
Yeah.
reason I'm bringing it up because
Yeah.
I see your point, but also to the point that did he have a meeting with the and then he brings up all the dates. Did he have a meeting with the University of Idaho to bring up all the dates before this?
Interesting.
I'm like, okay, he's not bringing up, like, he's sort of evasive about who he has a meeting with, but we had a meeting with you know, and then he immediately starts bringing up all these, you know, dates, and I'm like, hold up a minute, hold up, you know, there's something fishy here. So it could be your way. I don't know. It could be my way.
I don't
Or did
know.
they have a meeting at McDonald's this morning over biscuits and coffee? Like, this is going to crap. What were those dates again? What the
Oh,
you know, what the heck?
it could have been a piece of paper and dates in front of him, you know?
Yeah.
They just coincide with March of 2025, right?
Oh shit.
Oh yeah, we're thinking alike.
Yeah.
Yeah.
No, but I mean, like, he's very evasive. I'm like, did you have a meeting with Mr. Green there, like, regularly, and then you guys decided on these dates? Is that what's happening here? You know,
Oh,
maybe at McDonald's. I don't know.
yeah. It better have some butter and jelly, damn it, with them
Yeah.
biscuits.
Yeah.
Those
Over
are
there.
dry biscuits.
The sausage egg
Sausage.
McMuffin, that's the way to go.
Yeah, Detective Golden, they had sus cakes.
Yeah.
Oh shit.
That's right.
They're yummy because you don't know what's inside the middle.
That's
Yeah.
right.
Yeah, it's this is what I was wondering. What is the prosecution mentioned a little bit ago? What other investigators are they worried about? You know, Ann Taylor already states, this is not for these people to look at it and for these people to see it and for these people to go through it. It's just for these people that they already know their names. They haven't denied it. They've agreed that, you know, these investigators, they agreed to, like, but even after she says that, the prosecution team's like, we just don't want any other investigators being able to look at the documents. It's like, what are you trying to argue right there? And judges, it's sticky for you to try and figure out why you don't want the change of venue. People thought OJ's trial wasn't gonna be, but I mean, Yoli, in the beginning of OJ's trial, did people think it was gonna be 7 months?
No.
No, they didn't. So if Bill Thompson, and this is why I say Bill Thompson is arguing why it should be a change of venue with his argument of why it shouldn't be changed, because dude, you already tore down the house. If the house was still there, that the trial better be there for the jury. It better be there. You tore down the only reason for this trial to exist. They don't have any room.
I mean, they
Even
could
with
yeah.
Mm-hmm.
you can barely drive two cars in a different direction on their streets anyway, and there's parking allowed. Okay, you know, there's not enough lodging. There's no way in hell enough lodging. Most of your lodging is going to have to exist 2, 3, 4 hours away.
Wait,
Uh,
you're absolutely right about the house. That was the only reason to keep
the
the trial
only,
there. You're absolutely right about that.
the
That's
only.
the only argument they should have gone with. Boom. There you go.
So
Yeah.
why is it sticky? And Bill Thompson, he's even talking about, he keeps bringing up Boise and how Boise was one of the first cities, and they were always discussing the case, and they were always, you know, like bringing attention to it and stuff. Well, you know what? You just argued for Boise having an invested interest in this case then. So move it to frickin' Boise.
Mhm.
And why is it so
Mhm.
sticky for you to decide right now, Judge? Ann Taylor's sitting here saying, Judge, we need to, we're going to, I mean, and is this surprising to you, Yoli, that she would sit there and say, hey, I'm going to fire this cannonball. I'm going to fire this cannonball coming up. I'm letting y'all know I'm going to fire this cannonball, is because she's like, look, this has to have a change of venue before we set a trial date, before we reach out to jury, before we figure out what we're even going to do, because there's no way in hell Moscow can handle this.
Yeah, it's about Moscow being able to handle the case. It's not so much about like prejudice because everybody knows about the case, right? And the standard is whether or not you can be impartial, even though you know about the case. Can you follow the law? Can you be impartial? The juror says yes. Well, then you have no reason to kick them off.
Yeah.
If they say no, I already have my mind made up, then you kick them off. But
he gets pissy. He gets pissy because I bet you their jury pool that they're looking for is the fucking farmers up in northern Idaho. And where are you going to get them? You're going to get them in Moscow, right?
Yeah.
He doesn't want people that are used to reading documents and news articles and all these other things on a daily basis. Look, I'm not out there. I'm not out there farming. I'm running a YouTube show. You know what I'm saying? If I was doing a farm, I probably wouldn't be able to be on YouTube very much, right?
Right.
So Boise, that's not the pool they're looking for.
Right.
No, and they're high. I mean, not to disparage the farmers at all,
No,
but not at all.
They're hardworking people.
Yes,
they're out there working in the farm field 20 out of 24 hours a day.
They don't have time.
Right, unless they have
Right.
I'm not disparaging at all. I'm saying unless they got a YouTube feed up in their in their farming equipment or something, which I'm sure some do, but other than that, I don't think so. They're
right.
too busy worrying about us having good food. Which
Right.
they should be, yeah.
Yeah, and that's great. It like typically says farmers. That's exactly what I wanted to say. Is farmers aren't BK's peers. As far as being educated on DNA evidence, IgG, all this kind of stuff, they're not. And it seems like for the prosecution, they would be more malleable because you have these lawyers saying, "Hey, this is what this means, and this is what this means," when it's not necessarily true. But if you confuse, kind of like back to OJ, when you confuse the jury because they don't have that knowledge and it's not something they're used to hearing, you're kind of going to go with, oh, well, these are, educated attorneys. They know, they're telling us the truth.
Mm-hmm. Just like everybody else when they trusted the sock full of crumpled up paper. They're like, yeah, Bill Thompson's, he's got an impeccable record. Why would we question him about the photo? We don't need to question him about the photo. We trust him.
Yeah.
They all work together. They all hang out at the same Denny's on Tuesday afternoon.
Exactly. Yeah, and I mean, and unfortunately, but Ann Taylor's right. You can't wait till the last minute. Then you're talking about, oh, we're going to wait to decide if there's going to be a change of venue. That's crazy. People have to plan lives, and the city. If you are bound and determined to have it at Moscow, you're going to have to make some physical accommodations.
They can't though. Think about it. The only accommodation they're so worried about when school's in session, that means that they're worried about the 12,000 students that are coming back to the University of Idaho. And then the parents that are staying in the lodging and all the events that take place in the sports games and all this other stuff. They don't have the room. And why is it a sticky thing for you, Judge, when you can sit there and, like we always discuss, nobody thought OJ's trial was going to last 7 months. Guess what? This is one of those generational cases that's going to be like OJ because it's all brand new. The cast data, the DNA, all of this stuff, it's brand new.
So all the witnesses.
Right. And all the shoddy ass police work that we kind of go through on the OJ show. And if you're saying you want to crumple it in 2 months, Judge, it's what happens if it goes 7 months, Judge? Then the whole community goes to fucking shit. Why is it sticky?
Exactly.
So you look at the farmer quote you just mentioned, and you see that in how they try to railroad this whole situation is like, don't look at the IgG, look at the piece of paper we gave you with the outline. It's sort of the same thing. Look at the piece of paper we gave you with the outline. It says everything. That's a bullshit. That's bullshit. And she's like, I need to have an investigation team. Look at the whole picture, the totality of it. I can't have a piece of paper. So that's the difference. Like they're trying to railroad it into simplicity when this is complex, right? And it's very telling the two
What
teams how
if
they're playing.
what if Ann Taylor wanted check this out. What if Ann Taylor wanted to make the prosecution team think they wanted a speedy trial to fuck with them because she knew that they were going to be coming in with a whole bunch of unorganized shit. And then they're sitting there going, okay, guys, we got to get our shit together. All right, we got to get our shit together. It's going to be a speedy trial. It's going to, all right, here we go. We're done. We're done. We're done. And then she goes, just kidding. And then all of a sudden she's like, oh, okay, right? So now they're like, oh, fuck. Like, shit, now we're good. Like, well, yeah, shit. Well, we thought we were going to have an easy case because if we're thinking we're going to have a speedy trial and we gave them all the disorganized box of bullshit that we did, there's no way they can be ready to argue our piece of paper.
Yeah.
But now the tables have turned.
Correct.
Yeah.
Yeah.
I can see that.
Yeah.
And is not Farmer Fred.
It was a crossover, you know.
Yeah.
It's a crossover before the swish. It was like, whoop, made you think I was going right. Nope, I went left.
Psych.
Swish.
Yeah.
Yeah.
I don't know.
Hold those fingers up, lady. There you go. Right?
It's like Mr. Thompson is arguing the case for change of venue because he's basically saying that Moscow, Idaho can handle it. That it has to be set. That it has to be set during certain times because Moscow can't handle it. Well, guess what? There's a defendant, and I know he waived his right to a speedy trial, but there's a defendant that is waiting to go to trial. There should be some code that talks about all the factors you have to take in when you set a trial. And I haven't heard anybody talk about the code that says, oh, well, there's no parking, there's, it's school and, blah, blah, blah. There's no hotels. I mean, I haven't heard them cite any law to that other than it's just a logistical thing. But normally
it doesn't.
That could go up on appeal. And they say, you guys decided on this based on factors that are not supported by law.
Correct.
And maybe there is a law, I don't know, but I haven't seen any codes.
And Judge was also called for a jury duty in this case. I mean, how close
you gotta wait.
Get?
You gotta wait, man.
Yeah.
I don't see why it's sticky. He had to. Maybe he's never been to Moscow. I went there when there was just students, right? It was the week after Parents' Weekend. It was the same time that the crimes took place a year later. So, listen, if you're going to tell me, because the trial, if it goes 7 months, it could go to that point. And if you're going to tell me, I'm not going to bring up my footage, but anytime that we've went through my footage around 11/22 or even in Moscow, you see how cramped it is already. Can you imagine? All of the people that, parking, you wouldn't be able to even handle anything. And then if you have a football game, like, come on. You don't think people at Washington State, you don't think there's parents from Washington State staying in fucking Moscow sometimes just because it's closer? There may not be any room in Pullman and they need to stay in Moscow.
Well, you're going to have a media pool. You're going to have, as we spoke about last time,
make them drive 3 hours.
You have to sequester. You have to sequester the jury. How are you going to sequester the jury in a small town like that?
Yeah.
The 20-some person jury. How are you going to do that? There is no hotel rooms enough for them.
Make them drive 3 hours one way. So think about it. That's both ways.
So
and
they
then
bust them. They bust them in from
fall.
somewhere else every morning. The jury pool. I mean, that's just ridiculous.
It's a scary ride. It's a scary ride. Think about it. If you got to be to court at 8 a.m. in the morning, I'm telling you right now, it'll be a scary damn bus ride there and back because it is so fucking foggy before and after. I'm telling you right now, because even after like 6:30 or something, it gets so you can't see feet in front of you. It gets so foggy when you're
Hmm.
traveling up in that elevation. When you get outside of the city limits of Moscow and Pullman, as soon as you do, you're hitting fog. You can't see feet in front of you. That and then to do that for 3 hours, I
Mm.
don't.
And the
I,
jury would, like what Susan Russo said, the jury would be all alumni of the University of Idaho,
right? Yeah,
donating money to the University of Idaho.
right. Yeah,
Yeah.
everybody that's invested, right? Everybody that's invested. She broke ankles. Yes, she did typically. She had that Allen Iverson crossover on their ass when he did it to Michael Jordan when he was a rookie. He just went bloop. Oh, swish. All right, we'll get to the. It's just, I don't know. I don't
It's nuts.
understand what's sticky, Judge. And then when he's talking, it sounds to me like the state, like I said earlier, they're talking about highly sensitive information that they're waiting to get. He's sitting here talking he's still waiting for that sensitive information too. And I think that's why Ann says, I think that the prosecution's having just as much trouble as we are when it
Oh,
comes to getting some of this information. Because she's like, look, I'm not trying to, even though it looks like I'm trying to like sit here and go prosecution, where's the rest? Really, I'm doing all I can do because it's up to other people to give us the rest.
Hmm.
All right, here we go.
I was
Yeah.
looking at
they should give it.
whether or not
Sorry, go ahead.
Oh no, I just said they should give it, but
Classified.
happen.
Classified. Headers and redacted, Ann Taylor. There you go. December 1st, headers and redacted.
Yeah.
it was realistic
Unfortunately.
and fair, okay, trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, it just happens to be in pink highlight on my pad here, March 3rd, 2025. For trial.
Okay, I
Happens
had
to
no idea. I wasn't reading your mind
Oh,
or anything.
no
but
idea.
I thought that's about the mid and
I gotta pause it real
No
quick.
idea.
Bill Thompson, I didn't know it was in pink. What the fuck?
I had no
Bill
idea.
Thompson.
I wasn't reading your mind. We just came up with it. We did come up with it, but I wasn't reading your mind. We came up with it at coffee earlier, but I wasn't reading your mind.
Oh,
Yeah.
We just thought that would be a good date.
oh, is that the meeting he was talking about?
Yeah, of course it's a meeting. He was
There was
talking about.
absolutely no prior discussion.
Oh, Judge and BT had the butter and jelly jam biscuit and
Yeah.
coffee. Oh, okay.
Mhm.
And look how he says it. The way he says it.
Let me
He's
read.
like, "Oh, I wasn't reading your mind. It just so it's like,
Yeah.
you kidding me? Look how he says it. He says it like okay, like we're done.
That's why you hear so many alum comments in chat.
And look at the defense team. They're just sitting there like, how can they sit there with a straight face and not laugh? I like that. They're like just sitting there like, shit, I hope I don't laugh. I hope I don't laugh.
It's in pink, Your Honor. Thank you, Bill Thompson. I'm surprised you didn't tell us how the color pink was made because you know everything.
March 3rd, 2025.
Well, Your Honor, it just happens to be in pink highlight on my pad here, March 3rd, 2025.
Yeah, it's right here,
Okay,
Judge.
I
Okay, watch
had no idea. I wasn't reading your mind.
I had no idea.
But I thought
We didn't have coffee.
And I remember, Ms. Taylor, that you said
Oops. Oops.
I did.
Now
I
he's
didn't.
trying to justify it.
Yeah.
I know you didn't have jelly and butter on your biscuit, BT. I know you didn't have jelly and butter.
But I remember Ann Taylor saying it. We talked about it in our meeting, so we remembered you saying it. I remember.
Yeah. By the way, you left your coffee in the car. Make sure you get that out before you leave.
Shuffle paper.
Sorry, Ann Taylor. We
ridiculous.
Shuffle
told
paper.
you.
That's what he's doing. Shuffling paper. Shuffle paper. Shuffle paper. Look at that. Look at his shuffling. Like, go
Oh my
back,
God.
go back. He's shuffling paper. He's like, oh shit, shuffle paper.
Well, yeah, because they told Ann Taylor they were meeting for biscuits and coffee at 9:30, and they snuck in there at 9 real quick, and then she showed up. They're like, "Oh, you didn't get the memo? Sorry." But we told you, Ann Taylor. We told you we met for coffee. Okay.
Yeah,
Whether or
exactly.
not it
We
was
told you.
realistic and fair, okay, being trying to
JJJ
be
buttered.
compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, it just happens to be in pink highlight on my pad here, March 3rd, 2025.
Remember when I
had no
highlighted
idea.
it
I
over
wasn't
breakfast?
reading your mind or anything.
Yeah, what, guys? Yeah, I take.
I only had a pink highlighter.
I'm gonna start
I
showing
didn't have a yellow
you.
highlighter.
I'm gonna start showing you, everybody, the prep work that I do for every show in the beginning, so you guys can see that I actually do prep work. It's right here, everybody.
You gotta have a pink highlighter now,
It's
CJ.
right here. It's right here. Yeah, you know what? Maybe we'll go like neon green or something. I don't want to copy. I don't want to copy BT.
It would be pretty.
BT's in his own lane.
It
I
would
can't.
be funny if a pink highlighter fell out of the judge's coat right there. It's like, oh shit, that was mine.
You should have a T-shirt that says I wasn't reading your mind. And have it in pink.
All you Linda Lane sleuths, do me a favor. See if there's a pink highlighter on his table.
Yeah, do that. Scroll into that table real good.
Yeah. Transpose a pink highlighter.
Oh man, this is so.
All right, here we go.
I mean, could they not make it more Could they not make it more obvious?
It's scary. It's flipping scary, actually, if you think about it.
It is.
It is.
I swear.
It's a bombshell.
I would have said something on the record. I would have said, "Did you guys meet about this?
No.
Did you guys meet about this?
We told you 9:30. Sorry, and it was 9. Sorry. You didn't get the text, shitty coverage between Moscow Pullman. See, it says sent.
Yeah.
And I feel bad for her.
Oh, I left it on draft.
Because she's a woman, and it's like it's like the big boy, I just feel bad. That's terrible. She was excluded from her little pink highlighter conversation.
Yeah, we left it on draft. Sorry. I meant to send it.
They changed it at the last minute from Burger King to McDonald's. I'm sorry.
She was across the street.
Well, they're looking through the window saying, look at her. She's looking at her watch.
All right, BT, this is what we're going to come up with in 30 minutes. All right. Oh, shit.
I'm not reading your mind.
No.
Whoa.
No.
We don't do that here.
He needs to start his own YouTube channel, like the psychic judge.
He needs that Co-Burger chair. That's what
yeah.
Or a trial date and a scheduling order, if Your Honor is interested.
Shit.
I'm very interested. I'll tell you before you say anything about that.
Yes, sir.
I was looking at whether or not it was realistic and fair. Okay, trying to be compromising to some degree. I think it was March 3rd, 2025.
Well, Your Honor, it just happens to be
Look on his face.
Pink highlight on my pad here, March 3rd, 2025 for trial.
Okay, I had no idea. I wasn't reading your mind.
Like
but I thought that was about the mid. And I remember that would be the soonest you could be ready.
That was the everything
He's grinning.
went right.
Wait a minute.
And
Wow.
He's grinning.
I'll hear what their proposals are.
Okay.
Oh, shit.
Go ahead, Mr. Thompson.
Thank
Get
you, Judge.
jelly on your chin,
So we
Judge.
would propose that the court set March 3rd of 2025 as the start of trial. We would propose a September 6th, 2024 preliminary discovery deadline that would include exhibits known at that time. November 8th, 2024 for the defendant's discovery deadline. That would give them a chance to respond
Which you should have
to
had
any
already.
last minute discovery that comes out from the state. February 7th of 2025 for the state to disclose any basically reply or rebuttal to what we've learned from the defense discovery. That would include rebuttal experts. The defense's deadline would also necessarily have to include their mitigation evidence. We would suggest the court consider a final pretrial conference, kind of the pretrial wrap-up details conference for the week of February 12th to 16th, 2025. Since the death penalty related motions are already known and they aren't dependent on discovery, we would ask that any death penalty related motions defense have be filed by September 6th of this year. That the state have until October 11th to respond. The defense can then reply by October 25th and schedule a hearing during the week of November 4th through the 8th of this year. So we can get that wad of 12, 18, however many of those motions are going to be filed, we can get that handled. We would suggest that the court direct the jury questionnaires, if we can't agree on one, that the suggestions from the state and the defense be to the court by November 1st of this year. That would give the court the opportunity to finalize a jury questionnaire that the court is comfortable with, and it can be ready at the start of the next calendar year, which is when the next jury pool would be polled or would be drawn. And the court can, at that point, get questionnaires out to an initial panel and can assess in a timely fashion, are we really going to have venue issues in the early part of next year as we approach March 3rd. We propose the jury instructions exhibit list be exchanged by January 31st of 2025. And finally, as to pretrial motions, which would be case-specific motions in limine and those sorts of things, the deadline for filing, that would be November 22nd of this year, with the understanding that parties could file them early. I mean, the state already has been developing a list of various pretrial motions in limine that we think we'd like the court to consider, and we can file those early. But the deadline would be November 22nd, responses by December 13th, replies by December 20th, and then schedule a hearing on any of those pretrial motions sometime during the week of January 6th through the 10th. And I think
You have to write that down.
I have it all written down.
Sorry.
Yes, sir. And we can get it to you in writing. That's not a problem.
Okay. Ms. Taylor, so if things aren't going perfectly, of course they never do.
They never do, Judge. They never do. And I'll say it again. Death is different. This is a capital case. I've heard the court say the court only wants to do it once. I've heard the court ask, what can I do to speed things up? I need discovery. I need all of the discovery. I need the things that we've asked for. I need to not have to fight in motions to compel for things that was done on behalf of the state by the FBI that ends up being used against Brian or used in the investigation. I need that stuff.
Please do me a favor. I'm just going to pause it real quick. I know we all go through things in life and we all have, reality stuff that we have to go on and go through in our real life that isn't always positive. Sometimes it could be negative. I always do my best to make sure that anybody that comes onto the show doesn't see that I had a really shitty day. So do me a favor. If you had a really shitty day, please don't expose the chat to your shitty day. This is about peace, positivity, and progress, and we all need to make sure that that's what we're about. I do my best, and do any of you guys know whenever I had a really shitty day? Because I do have them. You guys don't. So please don't allow your shitty day to then also affect the peace, positivity, and progress, because I bust my ass for you to not have you have to go through it. Please bust your ass in my chat to make sure other people don't have to go through it either. Okay? Thank you. Not saying it don't happen. It's reality. I'm human too. But at the same time, I bust my ass for the PPP. Please, you as well.
I need When I ask for something, I need to get it rather than have to go back and ask and ask and ask again. And I'm not saying anything mean about Bill Thompson. I'm just not. I think he tries his very best, but I think he's hampered by the agencies and the information he gets from them. I can give you some examples. We asked for x-rays. We were told they don't exist. They're listed repeatedly in reports. We asked for them again. And I'm not sure if I'm getting them or not. The response is we have thumbnails, but we haven't found the actual x-rays. There's one example. I asked for certain mapping data done by a member of the CAS team. They said, you have it all. I said, no, I don't. I only have November 29th. And they said, oh, well, I guess we just didn't get that. Something didn't copy right. And I'm not saying anything mean about Bill or his office. I'm saying this is really difficult to drag the information out and
It's not
get
funny.
it to my experts or to understand it.
I'm just going to say this right now. It's not funny. You've been coming in here lately with bad attitudes every single time. I don't appreciate the disrespect. I've been very patient and I've been giving you 150, and I'm also giving you 150, not calling out your name on my show. If you want to remain, please be respectful, not only of me, the show, the guests, the people that we talk about, or the people that we show on the cameras and in this show. It's about peace, positivity, and progress. If you don't understand that, there's nothing else I can do.
And to hear that we're going to have a discovery deadline by the end of August is great. I need to have every piece of everything. I then have to have time to double check and make sure I really got it. I need to have time to get it to my experts and for them to have an opportunity to understand how that impacts their opinions, if at all. So I'm prepared for this case. And then we need time to get things to the state and for them to respond to what we send to them too. I know that this court wants to set this trial. These kinds of cases don't happen in a year. They don't happen in 2 years. They take a long time. This case is challenged with the way discovery has come at us. I'll give you another example. I open up, I get them and I list them in my computer by date. At one point, I gave the court a printout of that so the court could see how I'm getting it. And when I look in a folder, it has subfolders. And I might get some reports from Moscow Police Department with an FBI report. And an FBI report might reference an email. It might reference a photograph. It might reference a screenshot of a picture or of a phone that they took when they interviewed somebody. That's not with it. So maybe a few months later, I get some photos that has these screenshots in. And now I have to try to figure out who gave that screenshot, whose phone did that come from, which officer did that interview, and get them matched up and figure out if it's somebody I need to talk to. So not only do we have a huge volume of information, the way I get it is completely disorganized. And it's like if you wanted to play 52 card pickup with 100,000 decks of cards and throw them in the air, and I have to go figure out how to put them together. And by the way, the backs of every one of those cards look the same. That's what I'm doing. We also have science questions in this case. We have DNA, we have cell phone analysis, we have video analysis. The video analysis that the state really likes in this case, I don't have the full scope of that video with audio that should be available. They're working on it. They really are. I don't think they're not working on it. I'm just saying this is a real thing that takes time. And then you have the public nature of this case, and people don't want to talk to us. They're not wanting to talk to us. So we have to try to get witnesses, people that are listed in the state's discovery, to talk to us. We have our duties that are required with mitigation because there's no break. I don't get to go to trial on the innocence phase. And then if something goes wrong and Brian's not acquitted, I don't get time to go prepare that mitigation. I have to take another breath and start right there. So I have to have time to do all of that. Our mitigation expert is working as quickly as she can. She is meeting a lot of resistance to collect records and to conduct interviews. We're working through that as best we can. She has travel obligations to try to interview people. These things take time. I want all the discovery by the end of August. I love the discovery deadline by September 6th. That does not allow me enough time to get ready for trial by March 3rd. That deadline, that cutoff for us to get mitigation materials, that's impossible. That's just impossible. We've got the year pretty well scheduled out with what travel still needs to happen and what records still need to be obtained. So to have that to the state, I think they said by September, October, that's just impossible. I would request that this court take up our venue motion in May, make a decision on venue.
And I'll go ahead and pause it there real quick so we can discuss. That's a lot. You know, I don't understand why it's sticky. And Bill Thompson, he knows his ass is backed into a corner, so he's like, like those AZ, I'm hungry, I don't have a sandwich, here's a pickle. Like here's something that I can give you to kind of sweeten it, so we can like not get sitting here like getting accused of delaying the trial because she doesn't have mapping data. She doesn't even have the officers with the evidence and who she needs to talk to, who discovered this and who came up with this, and then to mention that they're all, like I said, they're all going to be in subfolders and everything. So, and they're not going to be the originals. So whenever you're talking about transferring data, sometimes during those transfer of data, it unfortunately puts new timestamps and new property information on those photos or images or documents or whatever, just from the transfer. She's asking for everything. It's no one wants to talk. Yeah, no wonder, because nobody wants to be the reason why BK gets set free, because their testimony isn't going to line up with what the hell BK's saying, or the prosecution saying. No timestamps, no dates on evidence she mentioned in the last court hearing. You can't even match up the investigator with the evidence.
That's right. She got a 50 million puzzle piece to put together in a month, basically, in layman's terms, is what she's saying. Like, you put together a 50 million puzzle piece in a month, and they're all the same color, all blue, right? So it's really sort of a task to go over the evidence. And if it's that messy, can you just understand how messy this investigation must have been?
Right.
If the discovery is this messy. It makes absolutely no sense. Yeah. Unless they did it on purpose, but
I think so.
I don't think so. I think they're just like, here, blah, blah, take it all as is, So it's scary to me. Having said all this, I have to get up and work really early tomorrow.
Thank you. I appreciate
I am so sorry. I have to leave. So thank you for having me.
Thank you.
This was very pleasant. Thank you all. Had some good laughs, and I appreciate you all. And thank you. And was very nice meeting you, Silky, and Yuli as well. And thank you, chat.
Yeah,
Y'all have a good night.
Meeting you too.
I'll try to listen in on my phone and stuff while I go to bed.
Thank you so
All
much.
right.
Appreciate
Have a
you.
good
Thank you
night.
for everything
Have a
you
good
do.
night.
You too.
Bye.
See you later.
Bye.
Yeah, it's like I not only I'm asking for the rest of this stuff, but at the same time, I'm still going through this stuff. I don't even, at this point, how is she still trying to find certain officers to match up with certain evidence so she can even question how they came to a conclusion or matched up something at this point in time? Like, how?
All I know, that body case, the UCI will body case, it was so complicated. There was so much evidence. Discovery referee and all of anybody who would exchange discovery, they would deposit it in a court reporter's tank. Like, it was like all the discovery would be deposited into the court reporters, and you had access to it there. So it couldn't be manipulated. You had access to look at it. And if you were going to print something, you had to log out that you're printing it. I mean, it was all, streamlined. So when I see this, when I see this kind of case, I would think that maybe in the criminal case they could have like a discovery referee and a central deposit where all this stuff goes. So, you're not having boxes of stuff and, files with folders and, I have folders of stuff and I get lost in my folders. I'm like, well, what folder did I put it in? I don't know how it's like, but I would think that maybe they should have something like that. But
This is a tactic. You figure it out.
Yeah.
We're gonna do it all disorganized.
Yeah. I was going to say, sorry about that. I was going to say the Delphi case is the same way. Same thing with the defense saying, hey, well, this is before the attorneys got kicked off and reinstated. It's a whole big mess now, but that's basically what they were saying, because the trial was supposed to start in January. And they were saying, look, by November 1st, we need all the discovery. And, when they did get stuff, that's what they complained about. Boxes, files, all this stuff. And they're like, holy crap, we can't get through this in time. And I'm like, why is it allowed? With all the technology we have for a fair trial, why can't you just list it, have it, scanned in, have an electronic record? I don't know. I don't get this. But you're right. It's a tactic. Yeah.
Yeah. And what did our forefathers do when they had one piece of paper and they couldn't write on the back? And they somehow figured it all out. But now that we're in a digital age and everything can be scanned and we can have it at the click of our mouse very easily. A huge library of information at the click of a mouse. How are we this far in what we're doing here when it comes to real truth and justice, which is what they're there for?
Right. It's just BS. I put my hoodie over me. It got cold again. Let's see, it's everywhere. You see?
Are you gonna show off the wings, Silky? Hold on, everybody. Let me solo highlighter real quick. Show him the CJ's Angel's wings there. Yep.
That's cute.
Over your whole back. Back.
And it's so warm and I love the front that says Silky.
What's up, Cherry? Yeah, here, let me solo highlighter again. Yeah.
I'm sorry about that.
Everything comes customizable with your name on it and everything and you even get an edition number too, because everything's going to be numbered inside of the t-shirt, so you'll have like an edition number too. But everything's customizable, your color, and we'll be having something for the fellas coming out soon. I'll show you coming out with the fellas. The ladies are gonna have the angel wings on the back, and the fellas are gonna have the devil wings on the back. So I think it's gonna be a nice hoodie for the fellas.
Well, I was excited because it, says angels, and I'm very rarely called that. Usually it's preceded by the term hells.
Nope, I'm not Charlie, I'm CJ. I'm not Charlie, I'm CJ. I'm evil CJ, right? So that's why the fellas are going to be my demons.
I can be a demon too.
Well, if you want to be a demon, listen. If you want to be a demon, you can be a demon too. Well, it's totally. Listen, it'll be whatever you have on the front that determines who. Like you only on the front. You can have the devil wings and the horns on the back of the hoodie if you want. It's up to you, and everything it'll be whatever color you.
Or maybe
want.
half and half. Half horns and half angel.
Yeah, there you go. That would be, that's a good one.
My two sides.
There you go. Or give you one angel wing and one devil wing, right?
Yeah.
Ooh, there you go. That's a good idea. All right, so let me see here. So she's like, we how can we even set a date? I'm still asking for stuff. We're not getting anywhere. Yeah, and he's just sitting there like, what do you guys want to do? What do you guys want to do?
And let's see where we can get with the discovery. I still need to read every bit of discovery that's come, and I haven't. I scan it when I get it, but to go page by page and read it and understand what it means, I'm not through 2023. I have a long ways to go. So I don't think that that is realistic to set it. I think if you set it for March, I'm going to be back here after the discovery deadline, and I'm going to be telling you there's no way that we're going to be ready for trial. I would rather this court set the change of venue, make that determination. Let's see where we get with the discovery by May. Probably the court would have a decision by the end of May, early June. Let's see where we are with discovery by then and set a realistic.
I'm gonna pause this real quick because I did forget to mention one thing. It's almost like Bill Thompson. Ever since the first time he said, I'm gonna reach out to him and let him, the other agencies, and I'm gonna let him know that time is of the essence. It almost makes me feel like he's saying, look, judge, look, defense, we're still waiting on the documents. We're still waiting. We promise they're coming. They're coming. We're still waiting. And it almost like that's what, well, maybe by August, we could get some more information, because he's like, maybe he's being gaslighted too. Maybe in August we'll give you something, BT. We'll see. Okay, all right, I'll tell him that. It almost makes me feel like he's just,
So
we're gonna
frustrating.
get it. It's coming. Like he's telling all the families, we got so much, just wait. We got so much, just wait. It seems like the same game. Like he's been doing it the whole time. And he knows, well, yeah, because he knows what's going to happen. It's just going to continue to get delayed until the court comes to a decision where they're like, dude, this has been delayed so many times. Like, what are we supposed to do here? And he knows that. He knows they're going to move on without it. I really do think that.
And look at his picture there. his picture there. He's just kind of like thinking.
What do you guys want to do? Yeah, what do you guys want to do? What do you guys want to do? What's up, Vega? How you doing? Good night, Kib Kitty. Thank you for hopping in. Appreciate you.
Night, Kib Kitty.
What do you guys want to do?
Patience. I'm
summer of 2020.
No way. She's
Well, thank you.
applaud her patience
Taylor,
too.
I can help in any way to speed things with, if there's problems with discovery, I'm happy to do that on very short notice. Just so that we can keep going. But you say, it'd be fantastic if you got all the discovery by August. Your mitigation person has been working already, right? And just to know that I'm not being insensitive about this, I did read the ABA supplementary guidelines for mitigation function of defense teams in death penalty cases, and it's huge. Okay, I get it. There are so many things that if you don't do, then it comes back as, well, you were ineffective. And those standards are high standards for sure. And it takes a lot of time. So, but I'm also thinking, if you get all the discovery, if you can, assuming that, which may be inaccurate, for the end of August, you're saying that you wouldn't be able to respond to all of that, assuming that it's even earlier, that you could not be ready for the beginning of March 2025.
That's exactly what I'm saying. I'm saying I love that discovery deadline. Let's shoot for that. And I think that would help me make a June 2025 trial. I think once we have that discovery, and I agree, we can file the challenges to the death penalty earlier, but the challenges to some of the things that are going to be contained in discovery, those we need to see it all and see how it interplays. I can do some things early, but I may be coming back and asking the court to reconsider if it doesn't go our way and we found something that we didn't have. I think a discovery cutoff is great. And I think the court has to manage that discovery. If we finally are up to the eve of trial and there ends up being a whole new dump of discovery, then the court has to look at that discovery and understand, is it exculpatory? Is it something that we didn't have a chance to prepare for and should be excluded? If it relates to anything to do with the death penalty portion of the case, then the court's going to be asked to strike the death penalty. I mean, the discovery.
So tell me if I'm wrong, but I feel like she's saying, look, if the rest of this evidence that the prosecution is waiting on to be delivered, if it all of a sudden drops in at the very last moment, then it shouldn't be allowed, because how are we supposed to be prepared if all of a sudden this discovery gets dropped 2 days before the trial date starts?
Right.
That's what it
Yeah.
sounded like to me.
Mhm.
Because,
Yeah.
like I'm saying, I think that
And
they keep telling them, we're gonna, it's coming. Well,
yeah.
and
And yeah. The other thing is, with regard to his alibi, she needs information to corroborate his alibi, and part of that might be the cast stuff.
well, why would she need information from them? If it's his alibi, shouldn't it be her own
Oh,
investigators doing the own cast data to determine if
because
his client was?
yeah, the cast data would show that if this is the phone ping data, it should show that he was driving around, which is what his alibi is.
Yeah, so she's asking the prosecution to supply the evidence that would be exculpatory that shows that his cast data wasn't there if they have their own cast data performed.
Well, I don't know that they have cast data that puts him at
They
the
claim
house.
they claim to have cast
Mhm.
data, but like why would she be asking? You know what I mean? If it's his alibi, she should be going in there with her own investigator or expert when it comes to the cast data, saying, here's my
Yeah.
this shows my client not driving around. Or like she said earlier, a witness, which could be somebody that saw his car and
Mhm.
saw him. Maybe it was at some kind of stop on the side of the road when he had to change a tire, and she recognized BK, the clothing he was wearing, and where he was at in proximity to the house when the crime took place. It could be a witness too, like she states. But why
Yeah.
would she be asking for cast data from, why would she be asking for cast data from the prosecution if they claim they handed everything over and she would need it for his alibi?
I don't know.
You know?
I
That's
don't
what
know. I'm
I
just
have the
thinking, if he
question.
was driving around, and he had a habit, because she framed his alibi as a habit. He had a habit of doing this. So, if they have him 12 times pinging in the areas, well, that would prove that his habit. And then if they had like a 7-Eleven clerk who says, oh yeah, he always came around here, at 2:00 in the morning, and he'd always get like a Twinkie or something. And that would be something that would support his alibi.
Well, he'd be
if
on
they had family
video
members or
footage.
friends.
Yeah. I mean, yeah.
Yeah.
But what I'm saying is, and I know she doesn't have it. I know she doesn't have
She
it.
doesn't
This
have
is
one.
this is what I'm asking. Why would you then? Why are you? And let's be honest. We already talked who has the cast data, right? So when it comes to the cast data, if she's able to give an alibi, which is my client was driving around so and so, she obviously doesn't have video evidence, right? Which would be like him walking into a gas station getting a whatchamacallit. That's why I refer to maybe he was on the side of the road replacing a tire, because he
Well,
doesn't have
I don't know
video.
if they have video evidence
But
because the gag order.
I don't think so. Otherwise, I think the video evidence would have already been shown when it came to questioning the validity of the grand jury, because then she would have said, "Look, here's video of my client getting a whatchamacallit, and he couldn't have committed the crime."
Yeah.
Grand jury
But
dismissed. That's
it's
why.
the habit though. That's the habit is what I'm talking about. But yeah,
No, I'm saying that's why she didn't. If there was video, she would have already played it. She would already in the grand jury indictment reversal. She would have went in there, because that's when she came in and said, "Look, my client was driving around." Well, if you want to get it dismissed, and if you have video of your client being at a gas station getting a whatchamacallit, well, you're going to show it in the grand jury uh, reversal hearing, because then that's going to show that the grand jury didn't have what they needed to then charge their client with the DP, because he's getting a whatchamacallit on video.
She doesn't get to introduce evidence to the grand jury.
I didn't say that. I said the judge. I never said the grand jury. This is regarding the grand jury reversal.
Oh.
Remember when she went into court and wanted the grand jury indictment reversed? Yeah, that's what I'm talking about. She could have went to the judge when she said to the judge,
"Oh yeah,
"Hey,
to the judge."
My client was driving around." If she had a video, she could have said, "Here's the video of him getting a whatchamacallit. He couldn't have committed the crime." Grand jury dismissed. Reversed. Because that would show that your client, that's why if she had video, she would already showed it. We wouldn't even be where we are today if she had a video of him being at a gas station or wherever on surveillance doing whatever to prove that he was at some other location at some other time. So when it comes to her saying my client's alibi is driving around, and if she's going to rely on CAS data for her own client's alibi, well, then do you really think that the prosecution's going to hand over shit that's going to help her?
Well, they have to.
They would have to if it's part of the investigation, but if it's not part of the investigation, well, then they don't have to, just like the photo.
Yeah, I thought it was part of the investigation, but it's been so long.
Just like the IGG, it's part of the investigation, but according to them, it's not part of the investigation. That's how I'm referring it to.
Yeah.
Not part of the investigation, even though it is.
Yeah.
Even though it is. So it's...
What happens though? Can I ask Yoli a question? Like, what happens if they say, if the prosecution says, like CJ said, it's not part of the investigation, then they can't bring it up in trial? Or what happens if they try to?
Well, I mean,
fight it, right?
Well, if it's in, there's probable cause, right? So whatever they use for probable cause, that's evidence, right? To detain him.
Yeah.
And then if that evidence holds up, because sometimes you might have a witness and then the witness recants, or who knows what. And then if you use it in the probable cause statement, then you develop it. In other words, it leads you to your suspect, and then you develop your case from there. And for some reason, I thought that the PCA, and it's been so long, I'm not even an expert on this, but for some reason, I thought that the PCA talked about him going there 12 times and stalking them. But that's what it said, that he was stalking them. And I remember thinking to myself, well, there could be an alternate explanation for that he likes to drive at night. And so that could be explained
Walmart,
that way.
You went to Walmart in Moscow because you get bags for your noodles.
Bags, yeah. Yeah.
And you're connected, and you're connecting to the tower that 1122 utilizes. I could in Southeast Pullman, I could connect to the tower that 1122 connects to. And I'm in Southeast Pullman, just a couple block area. And if you don't believe me, you can look it up and look at the cell phone coverage. It's true. Little teeny couple block area in Pullman. I'm connecting to that tower at 1122. He didn't even have to leave Pullman. Because everything in the PCA could utilize the same tower. Okay.
Yeah.
It's not Chicago.
But they don't have to put every piece of evidence in the PCA, do they? That was my understanding. Like,
No.
they just have to put enough
Just
in
a
there
they
for a
only
judge to
put-
sign.
Just a minimum.
Right. But since they arrested him in Pennsylvania, they had to have and Pennsylvania has a additional requirement for probable cause so that they can go in and arrest him the way they did, meaning, the Lisk killer was arrested in front of a phone store and just quietly taken in. This guy, the SWAT team. So to do that, you have to have additional probable cause. And what I think the additional probable cause was the IgG stuff. Because, judges don't know. They see that there's DNA and they think, okay,
He's going like this.
you know.
He's going like this.
He's going, well, there's IgG DNA, I'll sign it. And so that's why we're thinking that they had to get those IgG results expedited, or I don't know, because Ann Taylor did ask in discovery, times was that warrant submitted before it got approved? And I don't know that we ever got an answer to that.
I can imagine. It'd be like trying to get that last dollar bill you want to do to rinse your car up at the car wash, and you keep putting it in there, and you got to like do this against the corner, like, come on, you dollar bill.
Yeah,
that's exactly like you to try to iron it. And, come on.
Trying to get that damn dollar bill to get in there. Take it, it's real. It works. I know it's real money.
Yeah.
And I thought that was a good discovery request because I would want to know.
Oh, shit, yeah. DP.
But it's all sealed anyway. I mean, we don't get to see what anybody has.
This case.
But what I don't like that he just takes Thompson's word for it and says, I asked, he told me they weren't going to use it in the trial. Okay, but they did use it in the PCA.
Bill Thompson probably talks to him about how he can be a better judge when they're sitting at McDonald's having that coffee and biscuit. Judge, this is how they do it here in Idaho.
The PCA doesn't mean anything. The PCA doesn't mean anything. Forget about the PCA. Well, that's what led to him. That's
especially the IgG.
It's a
when you say the IgG, you didn't use the IgG. Well, then that means you didn't use the tip, and you use the damn tip, bro. You use the fucking tip because that's what they needed. Because you put DNA and you put his fucking name on the that's all they needed. They finally got that dollar bill to work. They just need.
That is such a good analogy. How many times did you submit that report?
Right? How many times you been at the car wash going, geez, come on, it's a real dollar.
Yeah.
Even that pop machine,
Oh my God, that's happening.
Yeah.
But
me too.
Yeah.
Right.
The what machine?
The pop, even a pop.
The what machine?
Even a pop machine. We call it pop in Ohio. I don't know what.
Oh, pop! I thought you said pot machine.
No,
no,
you're in
dispensers.
You're in California. You're in California.
I was like, man, I don't even have to see anybody. I can go to this.
Right. See, of course, she's going to say that. It's California over there.
See, it's a Coke machine here. It doesn't matter what you're getting out of. It's a Coke machine.
Yeah, we just have those kind of vending machines here. All right, here we go.
Recovery deadlines, critical.
Oh, you guys are crazy.
So I love that. I love that. What that means, if I have all the discovery by the end of August this year, it means that there is a stopping point where I can know I have it all. So I can confidently get the motions filed. I can confidently tell my experts, this is it. This is the scope of what you have to do. And I can have some space to read it all and understand it and get ready for witnesses too. If the court makes that deadline, know that mitigation is not going to be done by then. But if the court makes that discovery deadline, and then we follow that with our motion practice, and then our deadlines for expert disclosures and whatever's going to come from that, and our mitigation, we should be in good shape by June of 2025 to try the case. If we have that discovery come up, I think that's a great idea.
Ms. Taylor, Mr. Thompson?
Trying to figure out where to start first. Yes, discovery is fast. Yes, there are
Great fart.
things that Mr. Koberger has asked for that we've inquired, and we were initially told, no, you don't have that. And then we have gone back at the prompting of defense saying, you sure? I mean, it ought to be there. And for example, x-rays for the autopsy. Well, we just got those. The first came in with thumbnails. In today's discovery, Ms. Taylor's going to have the full size, which we were able to obtain. We saw he gave us thumbnails. These are useless. Give us the real thing. And through the coroner's office, we were able to finally achieve that. According to Ms. Jennings, we are better than 95% complete on discovery. So we're getting close. There are some things that are outstanding. There are some issues with what information is actually available to us. We have given Mr. Koberger everything that we have that we haven't asked for a protective order on or had some sort of dispute about. And we've given it to them frankly, in the order it's come in, instead of waiting to try to package it together and give it to them in a different format, just because they want it as quickly as possible. And I appreciate that. And we're going to continue doing that. It's going to benefit to have deadlines for everybody to have to work for here. I don't think just setting a deadline for state's discovery does anything other productive other than that initial stage. So if we're going to set discovery deadlines, we need a state's discovery deadline. We need a defense discovery deadline within a reasonable time after that and a reasonable time before trial, because we're going to then have to investigate whatever the defense tells us they might be using. And then, of course, an opportunity after we see what.
You're muted, CJ.
Damn, I was coming up with a joke.
Do it again.
I said I paused it real quick because Bill Thompson is like trying to come up with shit out of his ass, and unfortunately, he had a bunch of peeps with marshmallow on the inside instead of the steak dinner. So the gas that's coming out of his mouth is, it's not that good. It's not that good. He's just coming up with shit, and it's not working. It's just not working. This guy's just giving you a heads up. It's like the next 7 minutes. Of course, you need
deadlines.
Of course. Judge.
Come on. He's
Judge.
like, well, I think it helps. But what? You're just gonna have an open extended discovery forever?
This is the problem with Bill Thompson. He should have kept the sweet end of the deal for the very end of it. He should have flipped these two around, because when he said, look, I got a sweet deal for you. I don't have a sandwich, but I have a pickle. He should have waited until right here and did the in the middle, because then, it's more effective in the courtroom. He did the pickle, offer, and now he's standing there just going, because Ann Taylor was just, like we said yesterday, Ann Taylor came out swinging, and he was thinking they were at the batting practice, and she coming in like she's playing Game 7 of the World Series, and she is just swinging away at those softballs, just killing them. He didn't know what else to do. That's why I think the judge and the prosecution don't look like they know what the hell's going on, or don't even, like you see, they're all. It's because I think they're going, damn, Ann Taylor is. What do we say to this? Because she's right. She's right. What do we say to this? And I think it's just prosecution gaslighting. Well, we got 95%. We're waiting for that last 5%. That last 5% is what Ann Taylor's waiting for, and then when she's coming up with documents, there's another way they're gaslighting her. When she's coming up with okay, we're missing page. We got 26 and we got 28, but we're missing 27 that shows the connection. We see a little bit here. We see the name. We're missing the other. Hold on. Let us go through that again real quick. It's got to be in there. It's got to be in there. It just seems like they're. Yeah. Check the thumbnails. Check the thumbnails. You know, they're just gaslighting.
Yeah. Well, they have to say something. They have to answer. They have to argue something.
It's just. It sounds like he's just coming up with, like, the reasons he's coming up with for the change of venue not to happen. But Boise's so invested.
But you can't handle it.
Right?
You just said you can't handle it.
I don't think this judge can either. It just, I don't know. It
Well,
just seems...
I know, because judges have a lot of stuff, and they're not necessarily, they're not experts in these.
I
DNA
guess he's never done a DP
cast,
case either.
I mean, I didn't know what the cast was, but oh, really? Is that what they're saying?
Yeah,
is that what?
That's what somebody in chat said. He's never even done a DP case.
Oh.
No wonder he's wishy-washy.
Yeah.
Bro, give it to somebody else. You know what I'm saying? Give it to somebody else.
Wow.
Quit delaying this shit, because dude, when you said why is Ann Taylor asking for more evidence when you already set how many fucking deadlines, Judge? Like, the prosecution doesn't even seem like they respect your ass, because they know that you.
ATs in court with toddlers.
Yeah, that's what it's like.
I swear, sometimes I feel
like they're getting schooled. They don't know what to say.
It's like, Your Honor.
They don't know what to say, because they can't say, well, you're right, Ann Taylor. They can't say that. So what else are they supposed to say?
Yeah.
Yeah.
Let me give you a pickle. Have a pickle.
God, I would be on fire, but maybe that wouldn't be the case.
We're not going to McDonald's, kids.
I would be like, don't you understand?
80s. 80s babies. 80s babies. Love you.
Look at the PCA. Look what's in it. And you tell me if they used it or didn't use it, Mr. Judge.
You don't know what the hell's going on. You guys decide. That's what they're doing. They're the ones setting the dates and the deadlines.
Very, very
and he's going, okay, that sounds
themselves. Normally, I don't know. In civil, there's codes that set deadlines based on the trial date. I don't know why criminals not like that. I mean, I have no idea.
Hey, there's just one thing the judge says. I don't want this trial to be in 2025.
He has no clue what it
has. Yeah, we don't need delays, people. Well, then be a more effective manager of the fucking people you manage. That's what a judge is, right? You manage everybody in your courtroom.
Case, yeah. Mm-hmm.
Right. So why don't you do a better job, sir? Because if you were managing an airport crew that wasn't checking bolts on fucking doors that get sucked off planes, some of the real ones. Come on, Mal, you want to fly a plane anymore? No. Get rid of it. Change a venue. The reason you don't want to change a venue is because somebody else is probably going to take over the fucking case. No?
Yeah. Probably.
I think so. When somebody's like, don't go to the Supreme Court, they're gonna ask me what my opinions are, and you don't want that. Well, I hope they would. That means, dude, that threat was a bunch of bullshit, because if you're sitting there in the same sentence giving somebody a threat, they're gonna ask me for my opinion, Ann Taylor. Well, I hope they would. That means that your threat
weird.
That means your threat is like this much, like, come on, Judge. Don't go there, because I don't want you to make me look bad.
I think that's weird that they would ask him.
He doesn't want to look bad. And he'd look bad if he was a judge that was removed from the case for somebody else that could actually handle it. Because he probably is like Bill Thompson. I'm so accomplished. I've been the fucking man walking around this county for so long, right? I've been the man.
Yeah.
And now all of a sudden somebody else is going to take over my all-star spot. Oh shit. Now I just went from the all-star spot to the bench, and now I'm on injured reserve. Now I ain't, who wants to be on injured reserve? Nobody.
It's like Ann Taylor's like, look, children, come on. Let me read you the story. I'm
Yes,
going to read you
Mama.
the story. Okay, I'm going to read you the story, and you're going to follow it. All right, and you're going to do exactly what the story says.
Oh, that's the date you guys want? Okay.
I mean, Jesus God,
That's
aren't
the
there
date you guys want.
laws? I mean,
And this is Moscow. Shit's
like,
different.
it's just willy nilly. I mean,
It's different. It's that Stetson. It's that Stetson cologne cloud. You know. Whoa. We just walked back into 1967, everybody. You know.
you see the judge smoking a cigar.
We just jumped back to 1967.
God.
Blast from the past. That cloud, I tell you, it's like in the Bermuda Triangle.
Defense is proposing or is disclosing to rebut that in some fashion and give notice of that. So that package of 3 days are important. Pre-trial motion on the death penalty, I think that's important. We need deadlines, so we just get it done and over with. And both teams can prioritize based on the timelines what needs to be done when. I don't know the first thing about what's going on with defense's mitigation. Apparently it's been going on for a while. It sounds like it's going to be massive. That's something that we just don't have any insight to. We think that our proposals are realistic. We appreciate the fact that something could happen where it turns out that they aren't realistic, that something happens that we have to revisit. And I think we need to be prepared to do that. I think the last thing that I want to touch on real quick is the proposal to set a state's discovery deadline and set hearings on the change of venue is inadequate. As we've indicated, change of venue under the law, that motion is premature. We need to be able to give the court the benefit of what impacts publicity, for example, is having on our actual jury pool. We know there's publicity. Everybody can agree. There's been massive publicity, not just in Latah County, but I see more about it in Boise or hear about it from other parts of the state than what we're seeing locally. So the massive publicity, that's a red herring, realistically. There's publicity everywhere about this. The issue is whether the publicity and the nature of this case is such that we cannot pick a fair and impartial jury in this county. And of course, we know that just being aware of publicity about a case does not disqualify a jury. There has to be a showing that that publicity or whatever has impacted the juror to the point where that juror cannot sit in this box as a fair and impartial jury.
Yeah, Judge, you know how you come up with the color purple? You mix blue and red together, Judge. Like,
and Judge is like, wow,
whoa.
I never heard that. Ooh,
look at his like,
smart.
That's right. This was
amazing.
This was yesterday when we were watching this live, and I was like, oh, look at all the glittery things floating in the sky. Can you guys see that? Oh, there's blue, green, and purple. Wow, look at all those glittery things. Come on, man. Judge, you mix blue and red, and that's how you come up with purple. Okay.
And that's why you need a deadline.
Golly.
We only got 95% of the red, all right? We only got 95% of the red. We're waiting on that. We're waiting on that. But
Decision based only on the evidence presented in this courtroom. That's the issue that Your Honor is going to have to decide on the change of venue question. And you can't do that based on a bunch of affidavits from experts who say, Judge, there's been a lot of publicity. That doesn't cut it. So I think just having a state's discovery deadline and trying to prematurely move forward with motion for change of venue is not the right approach. We think that the proposals that we've made are reasonable, understanding Ms. Hayward has concerns about whether she's going to be able to meet those. And I think there are enough stages in there that if that becomes a reality, there's the opportunity for us to discuss that. Like everybody here, we only want to do this once. We do not want to invite error that we can avoid. Thank you, sir.
Yeah, thank you, Mr. Thompson.
Oh, yes, sir.
I think you said maybe you're like 98% on.
Probably a little bit more than 95% is what Ms. Jennings just told me.
95%. Okay. So if it's 95%, I mean, is it possible that it could be done before the end of August?
It's possible, and we are going to wait till the end of August to do anything. We will continue to disclose information as we receive it. I mean, that's not fair to the defense. That's not fair to anybody. Just sit on stuff and dump it.
They're going to keep poking.
We are hopeful that it'll be finished by then, but we don't want to have to face a deadline that we think there's a chance could be difficult to meet. No.
He is lying out of his ass because there is no way he's poking for more information that he doesn't want to use for the fucking trial. Yeah, Ma, I picked up the dog shit in the backyard. While he's sitting there playing games, lying his ass off. And then the mom goes to cook supper and opens the kitchen window, and she's like, gee, oof, what the... Yeah. Sorry.
That's why we proposed the early September date, which would be essentially 6 months from now.
September 6th, that's what you're saying?
Yes, sir.
I told you I was going to be a great night.
You said that would be fantastic.
That would be fantastic, Your
I'm in
Honor.
a great mood today.
And Your Honor can give us a January 2025 deadline if the court wants to set a discovery.
Go ahead. What?
I said, I think the judge is looking at the calendar because he was like,
yeah.
He's gonna send that telepathic signal. Wait, watch. He'll concentrate.
Right. He's gonna let you know he's looking at the calendar because he's covering all these other cases too. Damn, CJ. Sit there and take you 5 minutes to find one of your notes that you had prepped for this show. How dare you? No, it's all in front of me, everybody. My other notes are scattered on my desk.
Yeah,
it's just ill prepared. It's coming. You'll see them. It's no secret. I try other cases.
Great deadline for us too. Expert disclosures, I think maybe would take a little bit longer, maybe February of 2025. The court gives us a deadline for expert disclosures. I want to comment on the motion for venue change. Your Honor, because I filed a motion and the court doesn't have affidavits or the briefing to understand how we're going to approach this doesn't make it untimely. I'm fully aware that the massive amount of media coverage by itself isn't all of it. But I'm also aware that this case has had more media coverage than most other cases, and it continues. So there is an impact of that. There are other considerations besides just the massive amount of media and an impact on potential jurors. That's what we're going to talk about. I think it's timely. I think it's appropriate to set a change of venue motion. I think it is what makes the most sense for the court to make that determination and set a trial date from there. If the court sets one here and has to change it later, a lot of things have gone into play to get that trial date set here, to get the courtroom reserved, and a lot of people realize waiting until the court has heard the information, more than affidavits saying there's mass amount of media coverage, the court can make that determination. If the court agrees to change venue at that time, then it makes a lot more sense to just set that trial from there. I would think by the end of, or by May, when we can have a hearing, I would think I would have a better handle maybe on the process the state's going through now with its discovery. I will continue to make the utmost effort to get all the way through every piece of what I have now and continue to follow up with questions to the state so that we can try to have this discovery issue put aside. Once we have the discovery completed, I think that we're going to have a lot better idea of what the motion practice is going to look like and how long that's going to take. And it'll be a more realistic way to disclose experts to one another with the materials that's required under Idaho Rule of Evidence 702. I think that's a better way to go, even though you might not set a trial date today, because at least you'll set one that's really informed that maybe everybody can rely on.
Thank you. Well, I want to make an informed decision about changing venue, and it makes sense to me. I mean, it may be premature, but I'd like to see what the defense has to say about that, what you're going to present. So, unless I'm just curious to hear this, I can always deny it. But if it's sufficiently strong and persuasive, then maybe it makes sense to do that. But obviously, when just for personal reasons, I don't particularly want to go to another county well, weeks.
What does he say?
Necessary. I mean, we'll do what we need to do, but I'm not, as I sit here, I'm not persuaded that we necessarily have to change it. I think that's an automatic. And there are a lot of factors, and that's one of the reasons why I was looking at this patent case, which is that's court of appeals, but it goes through all of the other cases that have dealt in this issue.
Rambo.
So I'm thinking, you said mid-April that you would be able to file all of your declarations, affidavits, whatever you're going to do. Let the state know who is going to testify. If you're going to have witnesses to testify, presumably experts. We got a taste of that, sometime at the beginning of one of our hearings. So maybe I'll hear the same witness. I don't know, but so we'll say April 17th.
Yes, I can make
Okay.
it.
And
Highlight it in pink.
maybe we say the state has enough time to have their response by May 1st. What do you think? Okay.
I think that's appropriate, Your Honor. Thank you.
Because there may be experts on the other side too. So, and I expect the information that you're going to present both sides and with a brief. So obviously.
Rambo. Oh shit.
And I'm going to be in Boise the next week.
I'm on the wrong case here. Whoops. Shit, where's my prep? It's like I'm doing the lost DoorDash driver. Where's my prep? Oh,
You actually have other cases.
I was looking at Valo.
I've got that. I've got golf this day. Sorry.
Oh my gosh, I take better notes than a judge. I feel good. He's like, here, you show me where it's at. Look, he muted it. Look at that. I didn't notice this yesterday. Look at him. He's like, hey, can you show me? Can you show me where you wrote that down for me here? I didn't even do my own prep. He muted it. That's slick motherfucker. I never noticed it. Look at this. Hey, can you show me where you wrote that? Sorry, my fumbaloo. Yeah. Here, look at this. Can you show where exactly was this that you wrote? Let me. Okay. Yeah, right there. Yeah. Okay. Thank you. Oh man, I hate looking like a fool sometimes. I do cover other cases. Whoop, wrong side. Wrong side.
Afternoon of May 20th. That's a little far out, but we were already been talking about maybe having a trial starting in June. So.
Your Honor, can I have it before May 25th? A witness I anticipate is not going to be available starting May 25th. Starting May 25th, I think, for 2 weeks. So if I could have it ahead of May 25th, that way we
can have a jury trial that week, May 20th. This afternoon of May 14, give you enough time, Katie?
That was May 14th, Your Honor.
May 14, that's Tuesday.
Yes, Your Honor.
Okay,
Yeah, yeah,
let's
do.
say, how about 1:30?
Sounds greater.
Okay, 1:30, May
He does look
14th.
like Barney. Yeah, do.
I am going to make a determination about that presentation on change of venue before I set the trial.
Imagine the corns on his
It
toes.
could still be March 3rd, or maybe beginning of
What comes after March?
yeah, that's 2024.
Oh, let me look at my
I'm
calendar.
just still thinking of 2024. But it's hard. It is hard to think it.
Sorry, I was looking at 2024 on the wall. Oh, I forgot 2025 ain't on there. Shit.
Is he that? Oh. I mean,
Yeah,
is he?
he stopped through Pullman on the way into Moscow. He stopped
It
at
looks
the,
like he just. It looks like he just
stopped at
wants
the
to burst out
dispensary.
laughing. It looks like he just wants to burst out laughing.
Hey, there's that dispensary literally like 30 seconds before you hit the Idaho-Washington state line. Judge, he's like, man, let me go through and get a couple gummies real quick. One ain't gonna hurt me. One ain't gonna hurt me. And then he's sitting there going, whoa, whoa. It was legal when I took it in Washington. It was
My
legal when I.
calendar looks so big.
It was legal when I ate it in Washington.
These old judges, they have big old calendars on their side. You know, they're like old school with like big old numbers.
I need one. Shit, I just have a clock. I just have a clock. I need a calendar.
That is not a calendar. Boy, am I hungry. Why do I have the
They have
monkeys?
those old kind.
What's up, Kara? I told you at the beginning of the show it's gonna be a great night. I'm in a great mood tonight. All right, here we go. Well, let me check. I forgot it was 2024 up there. Whoops. Come on, Judge.
You're so far out.
Sorry, it's so far.
My calendar doesn't go that far.
So are the mushrooms.
Doesn't go that far.
Yeah, I can't read the small print that has 2025's calendar on it. You know, the little small section on the big calendars. Yeah,
Yeah.
What? Here, can you show me where the when have you ever seen that from a judge? I can't believe I missed that yesterday. Can you show me? And then he mutes it. Oh Lord, this is it's the best hearing.
I'm listening carefully to both sides.
Oh, I'm so
and
glad we went through it again.
It's a complicated case, and it's a death penalty case, and that adds a lot of. It really does. So I'm gonna hold. I would like you to send me your scheduling list, and I will.
You send me your calendar.
We're going to
You just sketch
a deadline of September 6th for.
He's gonna forget. They can put other
the
dates.
State and Ms. Taylor, did you say beginning of January?
Yes.
Okay, January. Give me a date.
Give me a date.
9.
Let me see both your calendars.
Look at he's smiling now. He's smiling. Yeah, he definitely stopped in Pullman.
Yes, of course. Any.
It was legal when I ate it.
I'll write them down.
Thank you, Your Honor. There's been an ongoing discussion beginning most recently with the state's request for scheduling order, and I believe Ms. Taylor briefly addressed it at the last hearing. There's been an ongoing discussion about the alibi deadline, and the state is asking the court to either limit the defendant to presenting evidence about the disclosure that he made related to the alibi, which was that he was driving around the night of the homicides, but not allowing any further discussion or evidence of an alibi, given the amount of time that has passed since the state requested that alibi disclosure. Alternatively, since it was in the court's scheduling order initially prior to the trial getting vacated, we would ask the court to set a 10-day deadline now because that is consistent with the alibi statute. The state does not believe it is appropriate to tie the alibi to the jury trial date in this case. The statute that sets forth that 10-day timeline is completely separate from Rule 16 and other discovery deadlines through the litigation process. I think at this point, there has been so much time that has passed, and it has frankly causes the state great alarm that the defense is discussing calling upwards of 400 witnesses during the innocence phase when we don't have, potentially don't have a full alibi disclosure. And when you look at cases regarding appeals from issues that arise during alibis that come up at trial, these cases are all defendants appealing a conviction because the state doesn't get a second chance. If the state gets ambushed at trial, that's it for us. We're asking the court to hold the defendant to a fair alibi deadline, and I think that the time has come. Thank you, Your Honor.
My understanding was that was it, but I may be wrong. Ms. Taylor.
No, when the court vacated the trial setting, the court vacated all of the deadlines, including the alibi deadline.
Damn, she's telling the judge how to be a judge. You guys remember when I was showing you guys the Moscow Cribs episode where I showed you the old video where they were walking in and interviewing Fry, and he was like, yeah. And then the camera guy was like, because they were trying to get the funding for the new police department. And the camera guy was like, so what do you do if you're going to hire another officer? And he's like, well, we don't have any room, you know. Do you guys remember the guy that was on his computer? There was
nothing on it.
Yeah, he was fake typing on a screen to make it look like he was doing something. The judge just did that. He just turned a few pages to make it look like he was busy paying attention and doing something, and nothing even got written.
But he keeps smiling. You notice he keeps smiling, and he's probably like thinking to himself, I can't feel my feet.
My toes are numb, Billy. I didn't know my toes would get numb.
Oh my God. His faces.
Yes. Yes, his faces and his smiles, like out of nowhere. Nobody's saying anything funny. He's just smiling.
Judge, anytime that I wanted you to watch my show when I was covering BK and I wanted you to see I was doing the right thing, don't watch this show, Judge. This show. Oh no. He ain't gonna.
It's like a skit out of Saturday Night Live. I mean, it's like
they need to make one. They need to make one. You know what?
Yeah.
Maybe one day when I have more time or something, or I'll start making skits, because I need to get back into like doing little acting videos and shit. I do these voiceovers and things, but I'd love to like give you guys characters with shit too. So
that
maybe
would be fun.
Yeah, that's in back to 1967.
Well, what do you think? Give me a date. What do you think? Where's my calendar? Let me see your calendar.
Yeah, come on, give me your calendars, guys. Come on. He's like, maybe you know something I don't know. Well, actually, Judge, we did this because this is what we were supposed to do. Judge, oh shit, damn it, Sally. Sally didnn't tell me it was right here. Shit.
That's because Idaho rule says we have to do it that way. Oh, okay.
Why are you making me look bad, Sally? Why are you making me look bad? Fucking interns.
So
that one I carved out as one that's
sorry, go ahead.
No, he even gives him more time than the 10 days she was asking for.
He just lets them pick the dates. It's great. It's great.
Was still held through when the court vacated the rest of its scheduling order. So I don't think that we're foreclosed from that. The court also has the ability to give an extension besides the limited time by statute. In this case, it's more than Brian was just driving around. We have let the state and the court know that we expect that will be supported by expert testimony and by cross-examination of the state's experts. I need their full cast report and the rest of the discovery related to that before I can say more about that.
Cast report.
So
Mm-hmm.
to tie me to a deadline when I don't have the rest of the discovery that I've been waiting for that would relate to that will mean that I will be back asking the court to reopen it. My expert can't finish until I get the rest of the discovery as well.
And the discovery you're talking about is a video of the car?
No, I am.
What do you,
So the video that we talk about is
last
one that I think the state's going to use in its case that I don't have full video on, that I'm not talking about any video of
Everything.
Brian's car. When I'm talking
Everything.
about an alibi defense, I mean,
Yes,
there's
IgG
video that shows it elsewhere that I haven't gotten to yet, which may be possible given the fact that there's a lot I haven't seen yet. What I'm talking about
It's
though,
a Kit
is
Kat.
the cast
Kit Kat.
report,
The cast
the
report.
drive testing information.
Cast report meaning the,
This-
identification of the particular car.
That is the cell.
Judge, she's talking about the meat and potatoes, not the scraps that are in the garbage, bro. That's what she's asking for.
Did you
Oh,
see that
so
reaction?
yeah. Oh, so you're talking about, yeah, because he doesn't know the fucking evidence.
Yeah,
They're,
and when, go ahead.
they're saying that it's in there, Ann. It's in there. There's a Kit Kat. There's a Hot Wheel in there. Trust us. You just gotta find it. You just gotta find it. It ain't in there. It ain't in there.
I was dying when she's talking about wanting the state's witnesses of the car and all this kind of stuff, and he's like, yeah, and he's nodding, and she's like, and we're gonna cross-examine the state's witnesses, and he's like, he furrows his brow, not his bra. His brow.
Are you on Coburger Island too? It's not Kopaka. She didn't. Everybody, she didn't say Kopaka.
Coburger.
Didn't say Kopaka.
Coburger.
I'm gonna have to come out with another. See, somebody on CJ's panel said Kopaka too. No.
He stuttered.
Coburger.
Yeah,
He
but
stuttered,
no, he
right?
he furrowed his brow, like, you're
Like-
gonna cross-examine, like, huh? It's like, this is new information, and I'm like, Judge. Yeah,
Oh my God.
yes, Mr. Judge,
Oh
that
my
is what we do in court. We cross-examine.
And
Write this down.
I will
Cross-examine
be doing it.
states with.
It's what we do.
They're experts.
Oh
Yeah.
my god.
Yeah. It's like,
They're
huh?
both. They're
It's
both.
like
They're
getting a
both.
butcher board.
They're both
With paper
schooling, Judge.
to Judge.
They're both
Oh my
schooling
God.
him. You got
Yeah.
Bill Thompson's always schooling everybody, but
I
Ann
was
Taylor.
so impatient watching this.
Yeah. This is. I knew it was
Come
gonna
on,
be a good
get
night.
with
This
it.
shit was fucking a
Have some
disaster.
coffee.
This shit was a disaster. It's like, man, this is
God.
okay. Man, them Kit Kat.
Get a
You should-
stimulant or something, sir.
You don't have to- usually they're not
Jesus.
expired, but these ones are. But these ones are. You got to look at the expiration dates,
Tower.
everybody. Be safe.
Oh,
Be
And
safe.
I'm
information.
with you.
Be safe.
So what that is going to show, and what the drive testing data is going to show, and what other reports related to that are going to be things that my expert needs to finish our investigation, and things that I need to formulate my cross-examination against the state's expert. So when I'm telling you that I'm going to do those things in alibi, I can't tell you more than that right now, but that's how we're going to support Brian's alibi, that he was out driving that.
Okay, so you're saying that you have not received the cell tower reports?
I have some data, some cell tower data, some phone record data. I have a draft of a cast report. The most recent information I have cast is the FBI doing their work. The most recent information I have is
Where's
that
Scott?
on March 31st, they expect for that report to be done through the peer review process. So I may get it a month from now. I need to get it to my expert to digest.
You ain't getting it.
There's materials that support their report that I don't have full disclosure of. And the state's aware of it. I think they're working on it, and maybe they're on that drive that I'll pick up today, but I haven't had them yet.
So you expect to get that in mid-March?
I expect to get their report after March 31st, after it's done. The supporting data, I'm not sure when it's coming. They tell me it's coming.
Okay, I'm gonna kick it back to the state.
Your Honor, I guess I'm a little confused because if
Well, I obviously am too.
I'm confused because if the
My
defendant's
toes are
alibi
numb.
is out riding around that night,
What a
I'm not
mouse.
sure what additional information his cell data could add to an actual.
I really gotta
alibi
go
defense.
pee.
It seems like what the defense is asking for, and they're being completely upfront about it, and
Fuzzy
I
light.
appreciate that. But what they're asking to do is essentially double check all the discovery before disclosing their alibi, and that's not what the purpose of an alibi deadline is. In fact, it's quite the opposite. There is case law that describes that given the ease with which an individual could fabricate an alibi, and certainly that's not what the state is accusing the defendant of doing. I'm using language that is in case law, though. Given the ease with which an individual can fabricate an alibi, that is a very legitimate deadline. It's a reasonable deadline. It's a reasonable demand of the litigation process. There is a reason why there is a 10-day deadline in the statute, and that is because the defendant is able to tell his counsel where he was that night. They can work together and formulate a defense, and they can disclose an alibi. That is the whole purpose of an alibi deadline. The state has complied with the discovery up to this point. We will continue to comply with discovery. We are disclosing everything that we have to the defense when we get it, unless there's some protective order issue. We are asking that the
FBI.
court hold the defense to a fair standard that has been set forth in this statute and that is constitutional under the United States Constitution and the Idaho's Constitution, that has been repeatedly upheld by the United States Supreme Court and the Idaho Supreme Court. Thank you.
Okay, I maybe dropped the ball, that went through the cracks that I didn't. I guess what I interpreted that as that was it for what we were going to hear about where he was and how he was established. The evidence that he was in a particular place. So once again, trying to be compromising, I'm going to give you until April 17th. You can submit the other information that you need to find for then. And that should be plenty of time because you're going to get some additional information from FBI apparently by the end of March. And we can talk more about that later at the hearing on the motion for change of language. So that gives you some cushion. I'm not going to set it for 10 more days, but I am setting that. And the reason for that is so you don't have an ambush at the trial. I mean, that's why that is established as law. Okay. Well, I think we've gotten somewhere. And is there anything else we need to address today, Mr. Thompson?
Can you imagine if that's how I ended a show? I said, I just sat there for a minute and I said to my panel guest, I said, well, I think we accomplished a lot tonight, Silky and Yoli. Is there anything you want to say?
We got somewhere tonight. I think we got somewhere.
What a joke.
Oh my God. You almost have to feel sorry for him. But I really think he can't feel his feet. I mean, that's what he's acting like.
No, he can't feel his toes. His toes are numb.
Yep.
Yoli, have you ever seen a judge act like that before in any of the, I mean, who cares if it's criminal or civil? Who gives a shit? Have you ever seen a judge act like that before? Oh, you're on mute.
Yeah, you're muted.
There was a judge, in LA that.
Oh yeah.
He always wore his robe. His robe, it was always undone. like it wasn't zipped up, and he would come out and he would sit with you at the table, at the council table, like he wouldn't be up there on the bench, and he would say, "Okay,
What?
so we're gonna," yeah, and he would talk to you, and it was that, oh, they're like, that's the crazy guy. He was like the crazy judge that just didn't follow any rules. He had like a Hawaiian shirt on,
Wow.
shirt on, jeans, and he'd have his robe open, just, and he was so nice, but it was very weird.
Yeah, I bet he was. He was
He
probably
pretty much,
He stopped in Pullman too.
yeah,
Squeaker.
he's the judge that let his chest hair come out and went like this on the table.
And he couldn't hear. The
I
reason why
bet he was nice to everybody. What's up?
he
sis?
couldn't hear it, he would get really close to you. He'd get
Damn, bro, it's like lay off the
really
cologne.
close to you, and he'd be like, "Yeah, okay, we're gonna set this day."
Oh my god.
Yeah, that was one judge that was very
Before
strange.
court, he's like making sure that chest hair, he's like combing that shit out too.
He was old.
So when you see him sideways, you see the chest fro sticking out.
Well,
You know?
no, but I mean, I've seen judges overwhelmed.
Poof.
You know, I've seen judges overwhelmed. They are overwhelmed with right now. They're totally
Yeah.
overwhelmed. Well,
See
but this
somebody
is kind
walking-
of strange. It's kind of like he's just like letting him, like, what date again? What date again? Like, what date? Like, he wants to laugh. Like, well, let me look. Can you show me? I mean, it's just.
Can you imagine a commercial like, whoa, look at that chest fro. It's so prominent. It's so prominent. Damn, I want a chest fro like that.
Oh
man.
wait, bailiff named Bull.
Bailiff named-
Oh, what's up?
Oh my god,
Y'all
That's
missed a good
crazy.
show if you're just hopping in.
was this bailiff
Oh,
named Bull?
the whole damn show. What a blast of 4.5 hours. Man.
And they would say, courts in session, all rise, and he would say, "Oh, you don't have to rise. You don't have to rise. Just
Yeah.
let's get on with it."
Yeah. He probably's like,
Yeah.
instead of all rise, he's probably like, hold on, just
Oh.
let me give you a side view of the fro.
Yeah.
All right, we're good to go. You just witnessed history. Consider yourself lucky. Oh shit.
So, yeah, he was one of the new. When I was a new
Sign it.
attorney, and I'm like, "Is this for real?" I'm like, "Is this for real?" And yeah, I want to say his name. I don't know that I should, but
No, I probably wouldn't.
no, he
Yeah,
seemed like a
CJ.
good judge.
CJ, will you please remove 47 or 4 hours 27 minutes to 4 hours and 29? Otherwise, I've already been warned before. I was even talking about it again because we were talking about the Mad Greek.
He's
and I
probably
was
hired
like,
by now.
I was like, I already been warned before last spring. You might want to take these parts out because my client name is in them, and you're associate my clients with some acts that they haven't been proven, just allegations. So, but if if you were in those shows back then, you know the kind of shit we were going into in their backgrounds, and it's no surprise why they reached out to me and said, "Hey, we love your show." So we're giving you a friendly. And I said, thank you. Thank you. Thank God they love the show because they might not have been so nice. So I appreciate it.
No, this
All
was
right.
this was just like a mess. This court was like mess.
Yeah, it looked like Ann Taylor was schooling everybody. She was the only one taking it seriously. And it's unfortunate, it's just like I said back in early November last year, they're just going to keep delaying it, and they're just going to keep promising that they gave everything, and they're waiting, and it's not going to materialize. And
Yeah.
they're just going to get to a point in court where,
It's like
sorry,
she's playing with kids.
yeah, we got to move on.
Come on, you guys.
She's
come on.
unfortunately she's in daycare with a babysitter that doesn't know how to manage children. That's what it boils down to. Like he's a daycare sitter
Mhm.
that doesn't know how to tell this kid, okay, you're not gonna go to the zoo if you don't be quiet.
This is a rule,
until
and this
somebody's
is
like,
what we're going to follow.
"Ah!"
Yeah.
You can't keep control. They would have had all of it already. Or force a confession from Bill Thompson that says, look, we can't get it because we don't have access to it. Instead, he keeps gaslighting them, saying, we'll get it. We'll get it. We'll get it, because he knows it's not enough. He knows it's not enough. He knows, and he's just going to keep saying, I'm waiting, I'm waiting, instead of being honest with the court, saying, look, we're not going to be able to get it because it's classified. Because then all of a sudden he's probably doing it because he's probably hoping that they do give him something because they don't have enough, is what it seems like to me.
Yeah.
Yeah, I mean, you would think that he would be able to get it all, but.
Right, especially with the DP. If you have the evidence, why is it so hard to get? Especially if it shows the connections. Why is it so hard? You should already have that already, because that would be the parts.
I mean, they don't have it done.
Right.
Yeah. They're still completing it, is what they're doing. Which
still
to me, honestly, when the FBI went back in there to do before they tore down the house, I don't know what they were doing in there, but I don't know that it was the whole, the imaging or whatever they were doing, because that house is already torn apart.
Yeah. Yeah, because it would be missing a lot of structures. They would probably just end up going off the other one already. And it's like, what were they doing? Maybe they were trying to see if, they knew the local PD was incompetent. Maybe they're like, all right, well, they jumped on our tip. Let's see if we can try and use any of our investigative techniques to see if we can come up with something else that they can have. Because if they look bad, we look bad.
Yeah.
Maybe like taking the floorboards and the wall boards, they're scrounging for scraps and trying to go up there with a plate full of fucking scraps. I don't know. It'll be interesting. It'll be, when it comes to trial, the evidence, that we don't have and don't get to see. Boy, if it ain't some ironclad shit, I'm telling you right now, that I don't care what jury it is, they ain't gonna buy this bullshit. They might have bought it if you didn't add the DP. Maybe. But without the DP, or with the DP, I don't see anybody. How could you yourself or anybody in the chat convict somebody if they can't supply what Ann Taylor's still, the 5%? The 2.55 terabytes that Bill Thompson says he's still waiting on, which is Ann Taylor's, the connections. Oh yeah, it's in that box. You just gotta look.
That's why I was so mad. I'm like, why are you saying this and trying to push this down my throat? This doesn't make sense. Like, what?
Yeah, it'll be a sad day if it ever comes.
I don't know, but you know what? We'll see what happens.
Yeah. Hopefully, all I can hope is that the state has the evidence that proves Kohberger is the person that committed this crime, because if they don't, what a complete injustice to the community, the victims, and the families. Because if you can't get justice, like he said the first time, how in the hell are you going to get justice the second time? It doesn't happen. Look at the statistics and the analytics. Peanut shells when it comes to justice at this point. So if it is that way, shame on them for not investigating instead of just being focused like the Oregon car, because I have a feeling it was treated the same way, and they just got in too deep. Too deep, and that's why they're still waiting. All right, everybody. Oh, sorry. Go ahead.
Oh no, I was just going to say, especially because it is a one of these DP cases. I mean, if it wasn't for that, if this was something else, but a jury is going to be looking at the severity and can they convict? If they're any kind of unbiased or moral humans at all, they're going to have some really good evidence.
Mhm.
And it's not looking good.
No, they better, especially with these experts, because you have to think
No,
the defense is in the benefit because they can tear it apart.
Right.
They're the ones creating it
yeah.
out.
Can you imagine the trial and this judge? I mean, can you imagine what oh my God, it's going to be interesting.
Where you object, objection leading, objection, hearsay.
Shit. I
No,
cover a
read
lot of
that
other
back.
things.
Can you read that back to me, the court reporter? What was the question?
Yeah.
Yeah, or mute yourself and ask Sally. What line is it on again?
Yeah. Show me. Here, show me.
Yeah. What a joke. I'm glad we got to cover this.
It was fun.
Look at those
It
fuzzy
was fun.
legs. Look at those fuzzy legs. My toes are numb. And he's probably swinging his feet like this under the desk too, just kind of going like
Yeah.
this.
He has this look like he just wants to laugh. It's just
he does.
He has a look like
yeah.
Like he's just trying to.
Yeah, he's holding back.
Yeah.
Yeah.
All right.
And he's like, telepathically, but we still doing McDonald's again in the mornings, right? Right, boys?
Yeah. I didn't know. I wasn't reading your mind.
Hey, we were out of grape yesterday. Make sure if you get there early, make sure you steal one from another table.
Yeah.
Okay?
That's right.
I don't like that strawberry shit.
Yeah. I mean,
It gives me heartburn.
That's the group text. In the group text about McDonald's, and hey, anybody driving through Pullman this morning?
Yeah, let's tell her 9:30 again. That worked out pretty good today. We almost got busted, Bill. We almost got busted. Yeah. Did you see? I was like one of those comedians in a skit where I couldn't stop laughing. Oh shit! I almost got busted. Yeah, you got busted. You got busted.
Well, he just like I almost want to say, is this a joke, people? Like, are you guys for real? Like, is this a joke?
Unfortunately, that's what it was. It was weird. It was just weird.
We're talking about the death penalty and four students who are brutally murdered, and I know we're talking about it here and we're laughing and all, but I mean, to take it all in, it's a serious thing, to take it all in. You have to make light of some of it. I mean, but when you're looking at it, it's kind of sad. I mean, if you were a parent and this is how they were conducting, I would have no hope that anybody would get convicted.
If you got gummies, you got hope.
Yeah, that's true.
You're like Superman. Yeah. Oh shit.
Yeah, it's just sad, but anyway.
It is.
Well, I promised to take some calls at the end of the episode. I'm only going to take one tonight, and you can have 10 minutes. So if anybody is interested in calling in and letting us know how you feel about this court hearing and what we talked about tonight, you're more than welcome to. I'll put the phone number at the top if you would like to call. It is 330-510-1110. And if you'd like to, you're more than welcome. Yeah, I'm glad we got to go through this again because I wanted to go through it yesterday. I mean, we had such a long stream yesterday. I wanted to go through it. But man, we needed to have a game night, and I was glad that we kind of took a break from true crime and had a game night. Got to play a bunch of different games. It was a lot of fun. Really
peaceful.
I
was slammed with work for the past couple of days.
Yeah, let me see what we got coming up for shows tomorrow. Let me see here. I do cover
the Memorial Garden. Yeah, you cover other cases.
Yeah, I cover other.
The Memorial Garden for future tragedy. They're gonna use it for future tragedy.
Yeah, you didn't see that?
I did see it.
Yeah.
Oh my God.
Isn't that a way to minimize the victims by, it's like when I was doing the video and I hated even using this example, but I like to try and like use different things to make you visualize in different ways, like, metaphors and stuff, And it was like these things where it was like, okay, they're sitting there talking about all future tragedies plus what they're talking about for the students. And you're seeing all they have was pegs and yarn and little teeny flags as of right now. And it's like, so you're trying to like, instead of graves and memorials of all these future tragedies, you're trying to minimize the 4 sticks in the ground amongst the other sticks that are in the ground. And I'm just like, what are you talking about? That's not like, how is that supposed to be? If you want to announce it's for future tragedies, do it after the memorial, you know?
Yeah.
Not that it can't
So
be.
they're saying they're anticipating future tragedies, which is
Yeah.
Yeah.
They,
Yeah.
They're still
That's
drawing it.
scary.
They're still drawing it,
Yeah.
the design. And they're already ready for future tragedies.
yeah.
What the fuck?
Jeez.
Yeah. Well, when you say something like that, it's like it can be used against them if something happens, and some other unalivings or something horrible happens, and then you go and you say, yeah, that's why you built this memorial for future. This is one of the tragedies, right? You knew that there were going to be tragedies.
Yeah.
After.
You knew it.
Mm-hmm.
That
I mean,
is-
we live in real life, but it's like, do your memorialize the victims, make it be about the victims, not everybody else that might happen. Make it be
Yeah.
about them. And then the next day or a week later, yes, we are.
Hopefully there are no more future tragedies.
Right.
Right. And you're like making this huge area for future. I don't know. It's just it was disgusting, and that's why I had to
Yeah.
make a video about it. Shout out Caddy. She dropped the video after the show one night, and I watched it, and I'm like, I heard that part about future tragedies, and I'm like, are you fucking kidding me? And then he like, watch the video, everybody. And then you see the guy say the future tragedy thing, and then in the next clip he talks about it being special, and then he does the fake cry pause shit, and it's like, bro, get the fuck out of here. Don't do this President Green shit. I know he's your role model, but he didn't do a good job of acting, and you don't either. It's disgusting.
Yeah.
Go watch it.
It's already been a year, and they've
It's
been
great.
getting money. They have like 800,000 now for this
800,000.
memorial.
Yeah.
Oh my gosh.
And
And
in
this is
the
what they
video,
have.
yeah, and in this video that just came out the night before, they wanted to put up. I made sure I put the phone number up in case anybody wants to donate. I made sure because they wanted to make sure. And if you'd like to donate, call 5 da 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 da. And it's like, you already got 800,000. What the fuck, bro? Why didn't you just make a memorial at the site? You're worried about parking. You're worried about water. Where the house was at, make it a little garden and some swings and a memorial. Where the victims parked, make that be a fucking parking lot for the memorial garden and whatever else you need the parking for, because you don't have parking. Make that your memorial, not sit there and
They're like,
4 sticks amongst 40.
This could be the place where all the memorials, future tragedies that happen, that are going to happen.
It's disgusting. It's disgusting.
It is. It is.
What if in Delphi they made a memorial for all the future kids that might be,
Yeah.
Here's this for
And these are
Abby and
future
Libby.
kids.
Yeah, here's this for Abby and Libby, but this is for all the future kids that might come down this trail and get kidnapped and unalived.
Well, but to be honest with you, Carroll County really should have something like that, because the rate of adolescent unalivings is phenomenal. Not just the Flora 4 and Delphi, but there's a lot. There's a lot when you go to look at it. So yeah, actually they need one more than Moscow.
Yeah, it's
It's ridiculous, though.
It is. And this is supposed to, like we always say, it's 2024. Why in the fuck are we here? Why is this where we're at? And how did we even get here when we're not supposed to go backwards, we're supposed to go forward? And with the technology that we have, how in the hell is that not even taking place? It doesn't make sense. Because I think what's happening is technology's
And then
catching
this-
up, and it's showing that these people ain't doing their job right.
Yeah.
They got away with it before. Now technology's surpassed them, and they can't be fumbling anymore because the technology will prove it. They can't say, "Yeah, he was driving around." Not no more. Not no more.
It's going to be interesting.
For sure.
All right, everybody. I'm going to go ahead and end it for this evening. I'll be back tomorrow. I'm sure we'll be talking about this case, and I'm going to try and do a breaking news show tomorrow for a little bit where we cover some of these other cases. But if I'm not able to, I'll probably cover everything in breaking news, and then we'll talk about the topic for tonight. Probably questions and contradictions. That's what we keep running into with this shit. With all these cases too.
There's so much out there right now, and also there's like leaked messages, and I don't even know.
Yeah. I'll leave that up for them. We got other stuff. Trust me, I have so much prep. We got so many other better things to get through, but I mean, I've seen the messages a long time ago. Okay, so what? It's discussion about Linda Lane. If you know it's about Linda Lane, it might not even be about Linda Lane.
They might not even be real.
But everybody thinks it's about Linda Lane. Everybody think, read them. Just like anything else. You know what I mean? You can read something and you can go however far you want to go with it. Kopaka. Thank you both for your time. It was a long show. Thank you, Silky Yoli. Shout out Golf Inspector General. Appreciate it. Thank you all for your time. We'll be back tomorrow night. Another awesome show. We'll be having a good time, a blast. And I'm going to try my hardest to be on tomorrow afternoon. I just can't make any promises. I got a bunch of stuff I'm working on trying to finish up. And I need to get that stuff done here. So we will be having a daytime coming up at some point. This weekend, Friday or Saturday or something like that. So thank you, everybody. Please hit the like if you haven't yet. Please sub. If you're not sub, please go sub to the other guests. I'll be dropping their links in chat as we end the show. And we'll see
I'll
you
hit you up, Silky.
Yes. We got to talk some body parts.
Body parts, and I'll be talking coffee.
Yeah. All right. Okay. Thank you, CJ. Night, Yoli.
Coffee, not body parts.
Bye.
Are you at the hospital? folks. I'm sorry, we're not copying your lunch location. Try that one more time, puppy.